This is an NBC News special report. Here's Kate Snow.
Good morning. We're coming on the air to bring you our special coverage of closing arguments in the murder and manslaughter trial of Derek Chauvin. He, of course, the former Minneapolis police officer charged with killing George Floyd last May after Floyd was arrested on suspicion of using a counterfeit bill. Bystanders filmed that incident, showing then Officer Chauvin pinning George Floyd beneath him. Everyone knows that video, kneeling on his neck for what prosecutors say was nearly 9.5 minutes. Chauvin and 3 other officers involved in the incident were fired from the department. The outrage that followed George Floyd's death, I don't have to tell you, ignited nationwide, even global racial unrest, protests over police use of force. In the past 3 weeks, the jury has heard from a total of 45 witnesses, with the most crucial testimony really coming from those at odds over exactly what caused George Floyd's death, if drugs were a factor, and if Derek Chauvin violated policy with his actions that day. Now the prosecution and defense have one last chance to make their case before jurors are sequestered for deliberations. So those closing arguments are set to begin shortly. NBC's Gabe Gutierrez has been following the trial all along. He joins us from outside the Hennepin County Courthouse. Those closing arguments, Gabe, set to get underway very soon.
Yeah, that's right, Kate. And this is a city on edge. Behind me, you can see this military vehicle that has been here for weeks. Now, more and more National Guard troops have been seen in and around Minneapolis. Some 300,000 troops have been activated in this region, some sooner than expected because of the shooting nearby just a few days ago in Brooklyn Center. Now, all eyes are on the courthouse behind me, though, because in just a few minutes, closing arguments are set to begin. We're expecting the prosecution to get its closing arguments, potentially play some short video clips, and ask jurors, as they did during opening statements, to believe their eyes. The prosecution saying that George Floyd died due to the actions of Derek Chauvin. Now, the defense is expected to come after. The defense has been arguing during this trial and calling 7 witnesses to do so, that George Floyd died from a variety of factors, not Chauvin's knee on Floyd's neck, but rather underlying health conditions as well as drug use, and that the officers were distracted by bystanders at the scene. After the defense give its closing arguments today, Kate, then the prosecution is expected to give a rebuttal, and then the judge will give the jury its instructions. As you mentioned, Chauvin facing 3 charges. It's possible, Kate, that the jury could get the case within the next few hours, and then jurors will be sequestered. Kate?
Yeah, Gabe, thank you. I know you've been reporting that this could all happen very quickly this morning, or not. We just don't know. NBC News legal analyst Joyce Vance is a former U.S. attorney. She's a professor at the University of Alabama School of Law and also an NBC News contributor. Let me go to you next about the prosecution. We mentioned all the witnesses. When you look at the split, the prosecution called 38 of those witnesses and set up a pretty dramatic case. What do you think they need to do today?
So we won't see high drama here. This won't be like television closings. The prosecution needs to be good technicians of the evidence today. This is their chance to remind the jury of all of the evidence, to encourage them to not be led astray as the defense tries to single out individual pieces of evidence and argue that that one piece of evidence might be weak, and to tell the jury that if they look at all of the evidence as a whole, from the early witnesses on the scene, the bystanders, to the medical experts, that this is a rock-solid case of proof beyond a reasonable doubt. And of course, the jury will consider 3 charges: murder second degree, murder third degree, and manslaughter in the second degree. I suspect the prosecution is really focusing on murder 3 here, but police cases are tough to convict in. Any conviction here will be a victory for justice.
Joyce, just quickly on that, for those who haven't followed this so intimately, can you explain, there are these 3 charges, and potentially the jury could find individually guilt on any or all of those charges, or none, right?
That's right. It's a little bit confusing. The judge will ask the jury to consider each of the 3 charges separately and return a separate verdict. So they could convict, acquit, or what's called hanging, be unable to reach a unanimous decision on each of those 3 charges.
All right, Joyce Vance, stay with us. Thank you. Let's turn to criminal defense attorney and NBC News legal analyst Danny Savallo, who's with us as well. Danny, the defense didn't call quite as many witnesses. What did they need to do to convince at least one juror that there's reasonable doubt?
The defense routinely will not call as many witnesses. There are many defense attorneys, me included, who have simply rested their case after the prosecution rests, calling no witnesses or evidence at all. And the reason for that is that the burden is always with the prosecution. It never changes. It stays with them throughout the case. And the defendant, my client, is cloaked in the presumption of innocence. And that's why you typically see a prosecution sometimes engage in overkill, but often put on as many witnesses as they can without being cumulative, and the defense putting on less witnesses so that they don't do anything to snatch defeat from the jaws of victory if they're already ahead. Now, strategy-wise, what the defense needs to do is push its two major themes. Number one, causation. The neck compression and subdural restraint did not cause George Floyd's death. It was his poor health, it was his methamphetamine use, and his fentanyl use. And central to that is going to be the testimony of Dr. Baker. Yes, that was the prosecution's witness, but he had some good tidbits for the defense to seize upon. Then you move on to the restraint itself. Was it justified? The defense needs to push that. They need to argue not only was it justified, it was certainly not a felony. It was not imminently dangerous because, they will argue, it was taught to police. It's something that, yes, you may have heard Chauvin's colleagues say, well, we don't like what we saw, but we called an expert that said this is something that was acceptable given the situation at that time and looking at all circumstances contextually.
All right, Danny, stay with us as well. I want to bring in Eugene Robinson in a moment just to reset where we are right now. We're waiting for this courtroom in Minneapolis, Hennepin County, to begin closing arguments today in the trial of Derek Chauvin. As we wait, let's bring in Washington Post columnist, NBC News political analyst Eugene Robinson. Eugene, I look at an op-ed that you wrote recently. You titled it "Chauvin's Despicable Defense." You clearly have a stance here, and I wonder what your take is on what today could mean for the larger community.
Well, look, the whole world is watching this trial. The whole world is waiting for the outcome, you know, to say something is potentially explosive, potentially a watershed moment, those sorts of phrases are overused. I don't think they would be going too far in this case. The George Floyd's killing resounded throughout the country and across the world, and was one of the sort of signpost events of our time.
Eugene, I'm going to interrupt. I'm sorry. We're listening to the judge now here in Hennepin County.
So members of the jury, I instruct you as follows. It is your duty to decide the questions of fact in this case. It is my duty to give you the rules of law that you must apply in arriving at your verdict. You have now heard the evidence, and soon you'll hear the arguments of counsel. At this time, I will instruct you in the law applicable to this case. You must follow and apply the rules of law as I give them to you, even if you believe the law is or should be different. You have each been given a copy of these instructions to follow along as I read, and you may take your copy with you when you retire to the jury room. Nevertheless, you should listen carefully and attentively as I read them to you now. Please note that the titles of the individual sections of these instructions are not a part of the instructions, but merely placed as headings to assist you in finding a topic. Deciding questions of fact is your exclusive responsibility. In doing so, you must consider all the evidence you have heard and seen in this trial, and you must disregard anything that you may have heard or seen elsewhere about this case. I have not, by these instructions, nor by any ruling or expression during the trial, intended to indicate my opinion regarding the facts or the outcome of this case. If I have said or done anything that would seem to indicate such an opinion, you are to disregard it. You must consider these instructions as a whole and regard each instruction in light of all the others. The order in which the instructions are given is of no significance. You are free to consider the issues in any order you wish. The defendant is presumed innocent of the charges made. This presumption remains with the defendant unless and until he has been proven guilty beyond a reasonable doubt. The fact that the defendant has been brought before the court by the ordinary processes of the law and is on trial should not be considered by you in any way suggesting guilt. The burden of proving guilt is on the state. The defendant does not have to prove his innocence. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. A fact may be proven by either direct or circumstantial evidence, or by both. The law does not prefer one form of evidence over the other. A fact is proven by direct evidence when, for example, it is proven by witnesses who testify as to what they saw, heard, or experienced, or by physical evidence of the fact itself. A fact is proven by circumstantial evidence when its existence can be reasonably inferred from other facts proven in the case. For example, if a person watches deer crossing a snow-covered field, the person has direct evidence of deer walking in the field because the person sees it. If the person does not see deer but finds deer tracks in the snow, the deer tracks are circumstantial evidence that deer walked in the field because that factual conclusion can reasonably be inferred from the tracks found in the snow. Now, attorneys are officers of the court. It is their duty to make objections they think proper and to argue their client's cause. However, the arguments or other remarks of an attorney are not evidence. If the attorneys or I have made or should make any statement as to what the evidence is that differs from your recollection of the evidence, you should disregard the statement and rely solely on your own memory. If an attorney's argument contains any statement of the law that differs from the law I give you, disregard the attorney's statement. The state has brought 3 charges, or counts, against the defendant. Each count charges a separate and distinct offense. You must consider the evidence applicable to each count as though it were the only accusation before you for consideration, and you must state your findings as to each count in a separate verdict, uninfluenced by the fact that your verdict as to any other count or counts is in favor of or against the defendant. The defendant may be found guilty or not guilty of any or all of the offenses charged, depending on the evidence and the weight you give it under the court's instructions. I'm about to instruct you on the law that you are to apply to the charges in the defense, but before doing so, I am going to define a few words and phrases that appear more than once in the elements of the charges and the defense that follow. The words and phrases being defined are bolded in the written copy of the instructions you will be receiving. You should use these definitions for these words and phrases in your deliberation. Attempted means that the defendant did an act which was a substantial step toward and more than mere preparation for causing the result, and that the defendant did that act with intent to cause that result. There are several forms of bodily harm relevant to some of the charges or the defense. Bodily harm means physical pain or injury, illness, or any impairment of a person's physical condition. Substantial bodily harm means bodily harm that involves a temporary but substantial disfigurement, that causes a temporary but substantial loss or impairment of the function of any bodily member or organ, or that causes a fracture of any bodily member. Great bodily harm means bodily injury that creates a high probability of death, that causes serious permanent disfigurement, or that causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily harm. To cause death, causing death, or caused the death means that the defendant's act or acts were a substantial causal factor in causing the death of George Floyd. The defendant is criminally liable for all the consequences of his actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes, if such intervening causes were the natural result of the defendant's acts. The fact that other causes contribute to the death does not relieve the defendant of criminal liability. However, the defendant is not criminally liable if a superseding cause caused the death. A superseding cause is a cause that comes after the defendant's acts, alters the natural sequence of events, and is the sole cause of a result that would not otherwise have occurred. To know, to have knowledge, or knew requires only that the defendant believes that the specified facts exist. Intentionally or intentional means that the defendant either has a purpose to do the thing or cause the result specified, or believes that the act performed, if successful, will cause the result. In addition, the defendant must have knowledge of those facts that are necessary to make his conduct criminal, and that are set forth after the word intentionally or intentional. With intent that, with intent to, or intended, means that the defendant either has a purpose to do the thing or cause the result specified, or believes that the act performed, if successful, will cause that result. It is not necessary that the defendant have this intent in advance. The necessary intent can develop during the commission of the act. Police officer means an employee of a law enforcement agency who is licensed by the Board of Peace Officer Standards and Training, charged with the prevention and detection of crime and the enforcement of the general criminal laws of the state of Minnesota, and who has the full power of arrest. A law enforcement agency is a unit of state or local government that is authorized by law to grant full powers of arrest and to charge a person with the duties of preventing and detecting crime and enforcing the general criminal laws of the state of Minnesota. The Minneapolis Police Department is a law enforcement agency for these purposes. The definition of any word or phrase with a specific legal meaning that appears only once in the elements or the defenses will be defined where it appears later in these instructions. The defendant is charged in count 1 with murder in the second degree in connection with the death of George Floyd. Under Minnesota law, a person causing the death of another without intent to cause the death of any person, while committing or attempting to commit a felony offense, is guilty of the crime of murder in the second degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of the crime of murder in the second degree while committing a felony are: first element, the death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd. Third element, the defendant at the time of causing the death of George Floyd was committing or attempting to commit the felony offense of assault in the third degree. It is not necessary for the state to prove the defendant had an intent to kill George Floyd, but it must prove that the defendant committed or attempted to commit the underlying felony of assault in the third degree. There are two elements of assault in the third degree. First, defendant assaulted George Floyd. Assault is the intentional infliction of bodily harm upon another, or the attempt to inflict bodily harm upon another. The intentional infliction of bodily harm requires proof that the defendant intentionally applied unlawful force to another person without that person's consent, and that this act resulted in bodily harm. Second, defendant inflicted substantial bodily harm on George Floyd. It is not necessary for the state to prove that the defendant intended to inflict substantial bodily harm or knew that his actions would inflict substantial bodily harm. Only that the defendant intended to commit the assault and that George Floyd sustained substantial bodily harm as a result of the assault. Fourth element, the defendant's act took place on or about May 25th, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find that any of the elements have not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons according to the instructions below that are listed on page 8 under the heading Liability for Crimes of Another. The defendant is charged in count 2 with murder in the third degree in connection with the death of George Floyd. Under Minnesota law, a person causing the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard for human life, but without intent to cause the death of any person, is guilty of murder in the third degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of the crime of murder in the third degree are: first element, the death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd. Third element, the defendant caused the death of George Floyd by an intentional act that was eminently dangerous to other persons. A person commits an act eminently dangerous to others when the act is highly likely to cause death. Fourth element, defendant acted with a mental state consisting of reckless disregard for human life. The defendant's act may not have been specifically intended to cause death and may not have been specifically directed at the particular person whose death occurred, but must have been committed with a conscious indifference to the loss of life that the eminently dangerous act could cause. Fifth element, the defendant's act took place on or about May 25th, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find that any of these elements has not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons, according to the instructions that are listed on page 8, under the heading Liability for Crimes of Another. The defendant is charged in count 3 with manslaughter in the second degree in connection with the death of George Floyd. Under Minnesota law, whoever by culpable negligence, whereby he creates an unreasonable risk and consciously takes the chance of causing death or great bodily harm to another person, causes the death of another, is guilty of manslaughter in the second degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of manslaughter in the second degree are: first element, the death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd by culpable negligence, whereby the defendant created an unreasonable risk and consciously took a chance of causing death or great bodily harm. Culpable negligence is intentional conduct that the defendant may not have intended to be harmful, but that an ordinary and reasonably prudent person would recognize as involving a strong probability of injury to others. Third element, the defendant's act took place on or about May 25th, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find that any of these elements has not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons, according to the following instruction on liability for crimes of another. The following instructions apply to all three of the charges I've just given you. The defendant is guilty of a crime committed by another person or persons only if the defendant has played an intentional role in aiding the commission of that crime and made no reasonable effort to prevent the crime before it was committed. Intentional role includes intentionally aiding, advising, hiring, counseling, conspiring with, or procuring another to commit the crime. The defendant's presence or actions constitute intentionally aiding only if first the defendant knew another person or persons were going to commit or were committing a crime. Second, the defendant intended that his presence or actions aid the commission of that crime. If the defendant intentionally aided another person or persons in committing a crime, or intentionally advised, hired, counseled, conspired with, or otherwise procured the other person or persons to commit it, the defendant is also guilty of any other crime the other person or persons commit while trying to commit the intended crime, if that other crime was reasonably foreseeable to the defendant as a probable consequence of trying to commit the intended crime. The defendant is guilty of the crime under this theory of intentionally aiding in the commission of a crime by another person or persons only if the other person or persons commit the crime. The defendant is not guilty for aiding, advising, hiring, counseling, conspiring, or otherwise procuring the commission of one of the charged crimes unless that crime is actually committed. The defendant, or the state rather, the state has the burden of proving beyond a reasonable doubt that the defendant intentionally aided another person in committing the charged crime. No crime is committed if a police officer's actions were justified by the police officer's use of reasonable force in the line of duty in effecting a lawful arrest or preventing an escape from custody. The kind and degree of force a police officer may lawfully use in executing his duties is limited by what a reasonable police officer in the same situation would believe to be necessary. Any use of force beyond that is not reasonable. To determine if the actions of the police officer were reasonable, you must look at those facts which a reasonable officer in the same situation would have known at the precise moment the officer acted with force. You must decide whether the officer's actions were objectively reasonable in light of the totality of the facts and circumstances confronting the officer, and without regard to the officer's own subjective state of mind, intentions, or motivations. The defendant is not guilty of a crime if he used force as authorized by law. To prove guilt, the state must prove beyond a reasonable doubt that the defendant's use of force was not authorized by law. You are the sole judges of whether a witness is to be believed and of the weight to be given a witness's testimony. There are no hard and fast rules to guide you in this respect. In determining believability and weight of testimony, you may take into consideration the witness's interest or lack of interest in the outcome of the case.
All right, well, we lost our feed there from Hennepin County in Minneapolis. You've been listening to the judge, Peter Cahill, describing to the jury what task is in front of them. We are awaiting closing arguments today from the prosecution, then from the defense, and then a rebuttal from the prosecution would be the third thing before the jury presumably would get more instructions and then be sent off to deliberate. Of course, we're talking about the trial of Derek Chauvin, accused of killing George Floyd. Let me bring in Joyce Vance. She's a former U.S. attorney. She's been with us all morning. She's been with us for weeks on this trial. Joyce, we just heard very detailed explanations of what the three charges are against this former police officer. I wonder if we could talk about the sentencing guidelines, too. We had shown on screen the maximum sentencing guidelines, but if the jury were to find, for example, in favor of murder, second-degree murder, it's unlikely they would necessarily go for that maximum penalty, correct?
Sentencing is always a little bit confusing. Typically, there are statutory maximums that are set in the statute and in state law. But most states in the federal system have adopted guidelines for sentences. It gives the judge a range in which he or she can sentence, and it is typically, as it is in this case, much lower, although still very substantial. One complicating factor that makes it hard to assess what the sentences here might look like is that the prosecution will likely seek to enhance sentencing based on some of the factual conduct involved in this case. And typically you would have a jury make those factual findings after they rendered a guilty verdict. But it might be the case here that Chauvin would waive that right to have the jury make those decisions and let the judge do it if the jury has already found him guilty. So lots of uncertainty here.
All right, Joyce, thank you. Let's go back to the courtroom and listen in on the judge again.
Parties introduced demonstrative exhibits in the form of charts, summaries, and animated videos. This information was presented to assist you as an aid in your understanding of the witness's testimony and to help explain the facts disclosed by the records, other documents, testimony, and other evidence that was received during the trial. If any chart, summary, or animated video is not consistent with the facts or figures shown by evidence in the case as you find them, you should disregard the chart or summary or animated video and determine the facts from the underlying evidence. Earlier during these instructions, I defined certain words and phrases, and you are to use those definitions in your deliberations. If I have not defined a word or phrase, you should apply the common, ordinary meaning of that word or phrase. During this trial, I have ruled on objections to certain testimony and exhibits. You must not concern yourself with the reasons for the rulings, since they are controlled by rules of evidence. By admitting into evidence testimony and exhibits as to which objection was made, I did not intend to indicate the weight to be given such testimony and evidence. You are not to speculate as to possible answers to questions I did not require to be answered. You are to disregard all evidence and statements of attorneys that I have ordered stricken or have told you to disregard. And with that, I'd ask you to put your instructions under your chair as we listen to the closing arguments of counsel. Is the state ready to proceed with closing?
Yes, sir.
Mr. Slisher, you may proceed.
it please the court, counsel, members of the jury. His name was George Perry Floyd Jr., and he was born on October 14, 1973, in Fayetteville, North Carolina. To his parents, George Floyd Sr. and Larcinia Jones Floyd, Sissy, the matriarch. Now, you met George Floyd's brother, Philonis, and you heard all about Sissy Floyd. She was George Floyd's mom. She was the mom of the house. She was the mom of the neighborhood. And you heard about the special bond that she and George Floyd shared during his life. You heard about their relationship, how he would always take time, special attention to be with his mother, how he would still cuddle with her in the fetal position. You heard that. And from George Floyd's brother, you learned all about George's childhood. And during his time growing up in that house, George Floyd was surrounded by people he knew, people who knew him, people he recognized, a familiar face to pick out in the crowd. People need that. George Floyd was surrounded by people he cared about and who cared about him throughout his life, throughout his childhood in that house, through his adolescence, into his adulthood. On May 25, 2020, George Floyd died, face down on the pavement, right on 38th and Chicago in Minneapolis. Nine minutes and 29 seconds. 9 minutes and 29 seconds. During this time, George Floyd struggled, desperate to breathe, to make enough room in his chest to breathe. But the force was too much. He was trapped. He was trapped with the unyielding pavement underneath him, as unyielding as the men who held him down, pushing him. A knee to the neck, a knee to the back, twisting his fingers, holding his legs for 9 minutes and 29 seconds, the defendant's weight on him. The lungs in his chest unable to expand because there wasn't enough room to breathe. George Floyd tried. He pushed his bare shoulder against the pavement to lift himself, to give his chest, to give his lungs enough room in his chest to breathe, with the pavement tearing into his bare skin. As he desperately pushed with his knuckles to make space so he'd have room to breathe, the pavement lacerating his knuckles. The defendant stayed on top of him for 9 minutes and 29 seconds. So desperate to breathe, he pushed with his face, to lift himself, to open his chest, to give his lungs room to breathe. The pavement tearing into his skin, George Floyd losing strength. Not superhuman strength. There was no superhuman strength that day. There's no superhuman strength because there's no such thing as a superhuman. Those exist in comic books. And 38th in Chicago is a very real place. Not superhumans, only humans. Just a human, just a man, lying on the pavement, being pressed upon, desperately crying out. A grown man crying out for his mother. A human being. And in that time and in that place, while he was surrounded in life by people he knew him, faces he could pick out, there was no one there he knew. He was surrounded by strangers. Strangers, all of them. 9 minutes and 29 seconds. He's surrounded by strangers, not a familiar face to say his final words. But he did say them to someone. He said them to someone who he did not know by name, but he knew him from the uniform he wore and the badge he wore. And he called him Mr. Officer. That's what he called him, Mr. Officer. Mr. Officer would help. We call the police when we need help. And he pleaded with Mr. Officer. George Floyd's final words on May 25, 2020 were, "Please, I can't breathe." And he said those words to Mr. Officer. He said those words to the defendant. He asked for help with his very last breath. But Mr. Officer did not help. The defendant did not help. He stayed on top of him, continued to push him down, to grind his knees, to twist his hand, to twist his fingers into the handcuffs that bound him, looking at him, staring down at times the horrified bystanders who had gathered and watched this unfold. The motto of the Minneapolis Police Department is to protect with courage and to serve with compassion. But George Floyd was not a threat to anyone. He wasn't trying to hurt anyone. He wasn't trying to do anything to anyone. Facing George Floyd that day, that did not require 1 ounce of courage, and none was shown on that day. No courage was required. All that was required was a little compassion. And none was shown on that day. George Floyd said, "I'm not trying to win." This was a call about a counterfeit $20 bill. All that was required was some compassion. Humans need that. People need that. But more fundamental than that, and more practical at that time, in that place, what George Floyd needed was some oxygen. That's what he needed. He needed to breathe. Because people need that. Humans need that. To breathe. And he said that. And the defendant heard him say that. Over and over. He heard him, but he just didn't listen. He continued to push him down, to grind into him, to shimmy, to twist his hand for 9 minutes and 29 seconds. He begged, George Floyd begged until he could speak no more, and the defendant continued this assault. When he was unable to speak, the defendant continued. When he was unable to breathe, the defendant continued beyond the point that he had a pulse. Beyond the point that he had a pulse, the defendant continued this assault. 9 minutes and 29 seconds. When the ambulance arrived, the ambulance was here, and the defendant continued. He stayed on top of him. He would not get up. He would not let up. He stayed on him, grinding into him, continuing to twist his fingers, to hold him down. He had no pulse. He was not breathing. He was not responsive, and the defendant had to know what was right beneath him. Right beneath him. You saw the video. You saw the point when the ambulance arrived, and finally, after a paramedic got out, and the defendant still did not get up, and the paramedic tapped him, and finally the defendant got up, and they lifted Mr. Floyd onto that gurney, and you saw the way he was not, there was nothing there. His head had to be held to prevent it from falling to the ground. He was completely limp. The defendant had to know that. He was there. He was on top of him. And he was on top of him. On top of him. Sometimes you ask for the truth, sometimes you insist on the truth. And the truth is the defendant was on top of him for 9 minutes and 29 seconds. And he had to know. He had to know. The medical examiner would find the cause of George Floyd's death to be cardiopulmonary arrest, complicating law enforcement subdual, restraint, and neck compression. Well, what you saw the defendant and the other officers doing to George Floyd caused his death. The medical examiner ruled the death a homicide, death at the hands of another. What the defendant did to George Floyd killed him. It was ruled a homicide. The defendant is charged with murder. He's charged with murder and he's charged with manslaughter. The defendant at the time was a police officer. Okay? It may be hard. It may be hard for any of you to imagine a police officer doing something like this. Remember, in jury selection, and we talked about bias and we talked about setting biases and preconceived notions behind. Well, imagining a police officer committing a crime might be the most difficult thing you have to set aside, because that's just not the way we think of police officers. We trust the police. We trust the police to help us. We believe the police are going to respond to our call for help. We believe they're going to listen to us. And this is strong. This runs deep. I'd say it's difficult to set this aside. I want you to consider that even after, with the bystanders, after they saw what they saw, after they saw this shocking display of abuse of police power and a man murdered in front of them, Genevieve Hansen, she called the police. Donald Williams, he saw this. You heard him. He testified. He called the police. A 9-year-old. Judea. What did she suggest? We need to call the police on the police. That's our expectation, even after seeing this, even after witnessing this. Our expectation is that the police are going to help. And with reason, and with good reason, right? Because policing is a most noble profession. It is. It is. And to be very clear, this case is called the State of Minnesota versus Derek Chauvin. This case is not called the State of Minnesota versus the police. It is not. Policing is a noble profession, and it is a profession. You met several Minneapolis police officers during this trial. You met them. They took the stand. They testified. Make no mistake, this is not a prosecution of the police. It is a prosecution of the defendant. And there's nothing worse for good police than a bad police who doesn't follow the rules, who doesn't follow procedure, who doesn't follow training, who ignores the policies of the department, the motto of the department: to protect with courage, to serve with compassion. Chief Arredondo The chief of police in Minneapolis Police Department, he took the stand and he testified and he told you what that badge that he wears over his heart means. It's a public service. It's a public trust. They're there to help us. It's a professional organization. There are standards, there are rules, there's a code of conduct, there's a use of force policy, there's extensive training. The police are first responders. They're who we call for help, and they help us. They have CPR training. If there's more training than simply use of force. There's more to policing than putting handcuffs on people and hauling them away, to be true, right? There's other kinds of training. There's procedural justice. There's crisis intervention training. There's medical training. And there's defensive tactics. And there's de-escalation. All of this training. Hundreds of hours of training. You met the people who staff the training center, and they told you, we don't train this. They told you that. The sanctity of life and the protection of the public, those are the cornerstones of Minneapolis Police Department's use of force policy. The protection of the public, all of the human beings that make up the public. The defendant, he didn't do that because that day his badge just wasn't in the right place. The defendant was a police officer. He was. And again, you need to set aside the notion that it's impossible for a police officer to do something like this. The defendant is on trial not for being a police officer. That's not the state versus the police. He's not on trial for who he was. He's on trial for what he did. That is what he did. That is what he did on that day. 9 minutes and 29 seconds. That is what he did. He didn't follow training, those hundreds of hours of training that he had. He did not follow the department's use of force rules. He did not perform CPR. He knew better. He just didn't do better. He just didn't do better. Remember during opening statement, counsel said that the defendant followed the rules and followed his training. Did you hear evidence of that? Did you hear evidence of that from the stand? Or did you hear something quite different? The chief of police testified. He violated their use of force policy. He violated their de-escalation policy. He violated the duty to render emergency aid. No. You heard the trainer, Lieutenant Mercil. We don't train this. This is not who we are. No. That representation was simply wrong. That's just a story. What the defendant did was not policing. What the defendant did was an assault. I'm going to discuss the law with you in a bit here and explain. The court's already provided you some instructions on second-degree murder, and you know, done in the laws of this state, if you commit a certain level of assault, a felony level assault, and a person dies as a result of your assault, you're guilty of murder. It's as simple as that. And what the defendant did here was a straight-up felony assault. This was not policing. It was unnecessary. It was gratuitous. It was disproportionate. And he did it on purpose. No question. This was not an accident. He did not trip and fall and find himself upon George Floyd's knee and neck. He did what he did on purpose. And it killed George Floyd. That force for 9 minutes and 29 seconds, that killed George Floyd. He betrayed the badge and everything it stood for. It's not how they're trained. It's not following the rules. This is not an anti-police prosecution. It's a pro-police prosecution. The defendant abandoned his values, abandoned the training, and killed a man. And why? Right out in the public, right out in broad daylight, in front of several bystanders as they looked in shock and horror. And why? Well, this all started over a call of an alleged counterfeit $20 bill. But George Floyd's life was taken for something worth far, far less. Far less. You saw the photo. You saw the body language. You can learn a lot about someone by looking at their body language. The defendant facing down that crowd. They were pointing cameras at him, recording him, telling him what to do, challenging his authority, his ego, his pride. Not the kind of pride that makes you do better, be better. The kind of ego-based pride. But the defendant was not going to be told what to do. He was not going to let these bystanders tell him what to do. He was going to do what he wanted, how he wanted, for as long as he wanted. And there was nothing they could do about it because he had the authority. He had the power of the badge and the other officers. And the bystanders were powerless. They were powerless to do a thing. The defendant, he chose pride over policing. Remember Charles McMillan, 61 years old, interesting man. Right? You remember when he testified, he had the glasses. If any of you in the front row, when he walked by, happened to notice his shoes, if you looked at his shoes, you probably saw your reflection in those shoes, right? He dressed for court like it was the most important day of his life. Interesting man. He was there. He's sort of narrating this horrific scene throughout. You hear him in the video. And he called out to George Floyd. He said, you can't win. You can't win. And George Floyd replied, I'm not trying to win. I'm not trying to win. I'm scared. But the defendant was trying to win. He wasn't going to be told what to do. He wasn't going to take a challenge to his authority. He was trying to win. And George Floyd paid for it with his life. Now, also need to be clear, this is not the trial of George Floyd. George Floyd is not on trial here. You've heard some things about George Floyd, that he struggled with drug addiction, that he was being investigated for allegedly passing a fake $20 bill, that there was never any evidence introduced that he knew was fake in the first place. Right? But he is not on trial. He didn't get a trial when he was alive. And he is not on trial here. Defense claims that he was non-compliant. Non-compliant. Well, let's revisit what happened before the 9 minutes and 29 seconds. Before that, it's Memorial Day, right? May 25, 2020, and George Floyd is sitting in a car in the driver's seat with two friends. Now, previously he'd been in Cup Foods. He'd been in the store. He was walking. He was talking. He was breathing. As alive as any person, any human in this room. Back to the car. He's with his friends, and there's a tap at the window. He looks to his left and is startled. This is what he sees. This is what he sees. Within seconds of the approach, Officer Lane have tapped on the window. Within seconds, he pulls his gun and holds it inches from George Floyd's face and starts shouting profanities. Show me your effing hands. Show me your effing hands. Screaming it. This is within seconds. You can tell a lot about someone by looking at their body language. How does Mr. Floyd look in this photo? Terrified? An officer on the driver's side, an officer on the passenger side. Lane orders Floyd to put his hands on the steering wheel. He does. That's not resistance, that's compliance. Lane orders Floyd to get out of the car. He does. That's not resistance, that's compliance. They order him, they want him handcuffed. He is handcuffed. That's not resistance, that's compliance. And on the handcuffs, you recall the testimony, they weren't properly double locked. And so they continue to ratchet. They're not on correctly, they're on too tight. Throughout, and you listen to the videos, throughout the videos, you can hear the sound of those handcuffs ratcheting tighter and tighter. Mr. Floyd is trying to explain to the police that his wrists hurt. Impervious to pain. Please. His wrists hurt. No one listens to him. But it continues. They tell him to go over to the Dragon Walk. He goes over to the Dragon Walk. That's not resistance, that's compliance. They ask him to sit down. He sits down. Not resistance, compliance. Not trying to escape, not trying to evade arrest, not trying to assault anybody, shoot anybody, stab anybody, punch anybody. No. Compliance. Sits down on the ground. They ask him his name. He gives his name. He spells it. That's not resistance, that's compliance. They ask him to get up, he gets up. They ask him to go across the street, he goes across the street. Right? Where's the resistance? Where's that? They take him over to the car, okay? They take him over to the car. George Floyd is a big guy, right? You can see here, I mean, he's almost as big as Officer Lane. He's a big guy. He's a big person. The back of the squad car is not. Right? That's what they wanted him to get into. And to George Floyd, he looked at that. What do you think that looked like? Like a little cage. Right? He tried to explain himself to the officers that he had anxiety, that he had claustrophobia. He explained this over and over. They wanted him to get in the back of this little car. And you know, he just wasn't able to bring himself to do it. He wasn't able to bring himself to do it.
Man, I'm scared as fuck, man. That's a breather's gonna go out on me, man.
Pull your legs in.
Okay. Let me count to three. And I'm going in. Please.
So he's trying to work up the ability to get in the car. He's explaining himself repeatedly. And you can see this is where the defendant and Officer Tao start coming into the scene. Right? And we'll look at what they saw in a minute. But they start to come to the scene. Right? A 19-year veteran of the police force with all of the training that involves, over 800 hours of training, 40-hour crisis intervention training course, a scenario-based training where they're taught to recognize the signs of someone who is experiencing a crisis. A crisis. You know, he couldn't bring himself to get in, and sometimes people can't bring themselves to get in. And this is not new. This is not groundbreaking. Okay? People have emotions. People have things happen to them. The police train for this. They recognize this. You don't get to meet the police on your best day very often. You don't call the police and say, everything's fine, just wanted you to know, right? That doesn't happen. Okay? No, there's a whole range of humanity out there who have a whole range of different issues. I mean, it could be anything. It could be a death in the family. Right? That can cause an extreme emotional response. You know, recall when Officer Lane approached the car, George Floyd talked about losing his mother. He'd lost her in 2018. Those wounds still right there on the surface. emotion. It could involve a divorce, finding bad financial news, right? Mental illness, mental health issues, like drug and alcohol abuse. All of those things can cause someone to not resist, but just not be able to bring themselves to comply at that moment, at that time. And this is nothing new. They train for it, they plan for it, they prepare for it, they have a policy on it, right? Recognizing persons in crisis. You remember Chief Arredondo took the stand. He testified that they have 4,000 calls for service for persons in crisis every single year. This is nothing new. They're there on a $20 counterfeiting charge. They train for this. They know about this. Now, George Floyd certainly had his struggles. You know that. The state put in evidence of that. Right? Courtney Ross testified that he struggled with an opioid addiction. You knew that. And this is nothing new. The difference, though, on May 25, 2020, the officers just wouldn't listen to him, wouldn't look at the signs, wouldn't recognize the signs of what they had prepared for. And a reasonable officer in the defendant's place, with all his training and all his experience, including that 40-hour crisis intervention course and the subsequent refresher course, should have known that and should have recognized it. Floyd was trying to get into the car. He was trying to work up the courage. He said he'd count to 3. But he just couldn't do it. So the defendant arrives on the scene. He surveys the scene. He saunters up to the car, and he slips on his gloves.
You can't win, bro. You can't win. I'm not trying to win. Go on, get in the car, then. I'll be on the ground, anything. Go on, get in the car. He know it. He know it too, Mr. Officer. Y'all hear me? Don't do me like that, man. Please. Okay, can I talk to you, please?
So you get in this car, we can talk.
I am claustrophobic.
I'm hearing you, but you're not working with me.
God, I'm claustrophobic, man.
Get in the car,
man.
Get in the car.
Get me in the front. Please.
No, you're not getting in the front.
I'm claustrophobic, Mr. Officer.
Get in the car. We're going to pull you in.
Man, okay? I'm not a bad guy, man.
Get in the car.
I'm not a bad guy. You ain't gonna win.
So they don't listen. They just shove him into the car, into that tiny back seat. You saw the look on his face. You saw the look on George Floyd's face when he glanced over into that car. It looked like he'd seen a monster looking into that car. Clearly, this trained officer should have recognized that and understood at that moment and that time, well, what is your goal? Where'd this critical thinking model go? Where'd that go? Where you take in information, you assess the information, you reassess the information, you consider what's the goal, what's the plan. You're there for a $20 counterfeiting charge, allegedly. Chief Arredondo testified they generally don't put people in custody for that. So why is it necessary to shove them in the car? They made a judgment call, they decided to shove them in the car. The predictable thing to happen, happened, right? He just couldn't be in the back of that car. And so they pull him out. They pull him out. And watch what happens. They pull him out of the car.
What? Please, man.
Hey, come on out.
Look at you. Thank you. Thank you.
Get him on the ground. Yeah, on the ground. On the ground.
All right, folks. They get him out of the car. He is handcuffed. He is on his knees. He is not going anywhere. There are 4 officers there. 4 officers. And what did George Floyd say once they pulled him out of the car? Thank you. Thank you. Now, a reasonable officer in the defendant's position at that time should have recognized and understood he wasn't trying to escape. He wasn't trying to punch anyone, stab anyone. No, he wasn't trying to do that. The problem was the back of the car. just like George Floyd tried to explain over and over. The problem was the back of the car. So if you can give them the benefit of the doubt that they made a bad judgment call and shoved him in the back of the car, at least when he came out in the struggle, it was over. He was on his knees. He was saying, thank you. Done. No need. It could have been over there. But what did they do? They took him from this position, handcuffed on his knees. They pushed him down onto the ground. Didn't need to. Not at all. For what? He's handcuffed. They pushed him down into what is, you now know, from watching the evidence in this case, the prone recovery position. Right? When he's down on the ground, he's initially pushed, he is literally in the prone recovery position on the side. That allows the chest to expand and provides room for the lungs to expand and take in air so they can breathe. That is a step that protects against the known danger of positional asphyxia. And they have him there. He's right there. So then what happens after? They take him incredibly out of the recovery position and prone him on the ground. For what? The prone position is a transitory position. It's a position you use to secure someone in handcuffs, and when you're done with that, you immediately roll them on their side. Right? That's the position he was in. Proning him was completely unnecessary. And this is where the excessive force begins. Right? This is where the 9 minutes and 29 seconds start, because they didn't just lay him prone. They did not do that. They stayed on top of him with a knee on the neck and a knee on the back, and the defendant's weight on Mr. Floyd, pushing down, with Officer King adding to the pressure, pushing down, holding his feet, Officer Lane holding his feet for 9 minutes and 29 seconds. That's when the excessive force began. That's when the countdown began. Now, you need to sort of pull back and take a look. You've learned a lot about policies and procedures and tactics. You have to pull back and say, would, but for the defendant's actions, pushing him down, would George Floyd have died that day? Was it drugs? He just miraculously die of a drug overdose in that time? Maybe it was the tailpipe. Maybe it was his enlarged heart. Maybe not. Use your common sense. Use your common sense. Believe your eyes. What you saw, you saw. Now, I'm going to talk to you a little bit about the law. The judge has already instructed you. And it's necessary to go over this a couple of times. You've learned you've gotten to go to medical school here as jurors. There's so many benefits to being a jury. You got to go to medical school. You got that free parking, great lunches, fabulous pay. So now you get a little bit of a free law school education. The judge gave you a preview of that. We're gonna go through that again. He's going to give you a copy of those instructions. You have them. You get to keep those and use those during your jury deliberations. He told you that you don't have to decide these issues in any order. You can do it the way you all see fit. I'll be making some suggestions as to the order I think you should do things that might focus your deliberations and just make the conversation a little easier, a little more focused. But you have these jury instructions as your guide. I think it's important for you to follow the judge's instructions to the letter. Right? The words and the definitions that the judge gives you, they mean what the judge says they mean. And know that the state is required to prove these charges beyond a reasonable doubt. Proof beyond a reasonable doubt. He read this to you. Proof beyond a reasonable doubt is proof as ordinarily prudent men and women would act upon in their most important affairs. And a reasonable doubt is based on reason and common sense, not a fanciful or capricious doubt or beyond all possibility of doubt. So reasonable doubt, it's just as the name implies. It's a doubt that's reasonable, a doubt based on reason and common sense. You as jurors are not required, nor should you, leave your common sense at the courthouse steps. As jurors, you must rely on your common sense. That's why you're here. We need you to apply that standard to these facts and to be a judge of the facts and apply those facts and findings of facts to the law. And so proof beyond a reasonable doubt, it certainly is a high standard. It's the highest standard. It's a standard that the state has met here. And the state does not need to prove its case beyond all doubt. It does not need to prove its case beyond what I'll call an unreasonable doubt. Not required to prove beyond an unreasonable doubt. An unreasonable doubt is a doubt not based on common sense, but based on nonsense. And you're not required to accept nonsense. You're not required to accept the notion that after the defendant kneeling on Mr. Floyd for 9 minutes and 29 seconds in the dangerous prone position, handcuffed, restrained, pressing down on him, that after that, as he was writhing in pain and suffering, that's not even a use of force. There's no force there because it's not likely to produce pain. A witness testified to that. You're not required to believe something that just flies in the face of common sense, to believe that you would have to completely abandon all notion of common sense, not likely to produce pain. You don't have to accept someone who says that. You'd be better off asking the 9-year-old. You're not required to accept the proposition that the car did it, that the car killed George Floyd. You're not required to accept that or to consider that it is the bystander's fault for distracting the defendant. You're not required to believe this amazing coincidence that after this 9-minute and 29-second prone restraint, that at that point in time, even though he was walking and talking, even though he was breathing, interacting with people, that he chose that moment to die of heart disease? To die of heart disease? Is that common sense or is that nonsense? Or that it was a drug overdose? You know that George Floyd struggled with drug addiction and drug use. You know that. You know he had developed that requires a tolerance. You know what the toxicology report says in terms of the levels, and you know what the testimony was about that. He had died of a drug overdose. That's not common sense. That's nonsense. Believe your eyes. What you saw happened, happened. It happened. The defendant pressed down on George Floyd, so his lungs did not have the room to breathe. Dr. Chauvin told you that. Dr. Smock, Dr. Rich, the experts who testified, you can rely on them. Dr. Smock, Dr. Rich, Dr. Eisenschmidt. They said like that commercial, right? They know a thing or two because they've seen a thing or two. They know a thing or two. Dr. Tobin knows a thing or two about how this works. So looking at the charges, and this is a little bit of a different layout than you see in your printed jury instructions, and they're not intended to replicate the instructions completely, but it's meant to be sort of a guide for you to look at the different elements in a particular context. And so the charge of murder in the second degree, murder in the third degree, manslaughter in the second degree, the judge read you what the law says those things are. And the law breaks down these different charges into things called elements. First element, second element, third element, fourth element. And each of these has to be proved beyond a reasonable doubt by the state in order for the defendant to be guilty of those charges. Now, those are the elements that are required. Those are the only elements that are required. Again, like other preconceived notions, you may have some ideas, from watching TV, about other cases and shows and things. You might have some other ideas as to what the law requires. But again, just like, it's, how it's lunchtime in court, and the judge tells you it's lunchtime, when it's time to go, the judge tells you it's time to go. Same thing. You know what the charges are, you know what the elements are because the judge tells you what the elements are. So you need to follow that. Okay? So talking about murder in the second degree, first, the death of George Floyd must be proved. Right? And then it must be proved that the defendant caused the death of George Floyd. And the fact that other causes may have contributed to George Floyd's death does not relieve the defendant of any criminal liability. It just does not. And for murder in the second degree, that the defendant at the time of causing George Floyd's death was committing or attempting to commit assault in the third degree. That's a felony level assault under the laws of Minnesota. And assault, to show the defendant assaulted George Floyd, that he intentionally applied unlawful force to Mr. Floyd without Mr. Floyd's consent, resulting in bodily harm. The state has to show that. The state did show that, the assault. And that the defendant inflicted substantial bodily harm on George Floyd. And that this act took place on or about May 25, 2020 in Hennepin County. Okay, so as to the first element, that George Floyd died, well, that was established. That was established by the emergency room physician, Dr. Langenfield. George Floyd was pronounced dead at the Hennepin County Memorial Hospital on May 25, 2020. So that element is met. And again, you can consider these elements any way you want to consider them. My suggestion is that you consider them in the order as listed here: murder 2, murder 3, manslaughter in the second degree, and in order of the elements, just because there's a lot here. There were 38 witnesses who testified. There are a lot of exhibits that were offered, and it's easy to talk about everything at the same time. It really is. But it will help focus your deliberations if you look at these different elements in order to have sort of a logical way to focus your deliberation. So I encourage you to do that, but you can do it any way you want. Okay. Second element, that the defendant caused the death of George Floyd. Okay. Causation. So what does that mean? What does causation mean here? It means that the defendant's act or acts were a substantial causal factor in causing the death. He's criminally liable for all of the consequences of his actions that naturally occur, right? Including those consequences brought about by intervening causes. The fact that other causes may have contributed to George Floyd's death just does not relieve the defendant of criminal liability. You have to find is that 9 minutes and 29 seconds of compression on his knee, with his knees on his neck and on his back, being held down, was a substantial factor in George Floyd's death. Now, if there was a superseding cause, then the defendant wouldn't be criminally liable. But the superseding cause, those are causes that come after the defendant's acts and alters the natural sequences of events, and is the sole cause of death. And we don't have that here. We know how George Floyd died. This is the use of force. When we talk about use of force, that's been defined by the different witnesses who've testified, looking at what happened from the point the knee went to the neck and back, right, and the unlawful restraint, the assault, started, and how long it lasted, 9 minutes and 29 seconds. Right? That's what that's what killed George Floyd. That's why he died. Believe your eyes, that unreasonable force pinning him to the ground, that's what killed him. This was a homicide. Now, you heard this from forensic pathologists, the experts. You've heard this, and the experts have weighed in. And Dr. Langenfield told you that Mr. Floyd died. Dr. Baker ruled this a homicide. He told you the cause and manner of death, the unlawful, the restraint and subdual by law enforcement. What they did killed him. Told you that. Dr. Chauvin, remember Dr. Chauvin, he told you specifically how it happened. He walked you through that, the asphyxia. Right? He told you how it happened. And the other doctors who testified, Dr. Smock, Dr. Rich, Dr. Eisenschmidt, they told you how it didn't happen. Right? It wasn't a sudden cardiac event. It wasn't a heart attack. It wasn't a drug overdose. It wasn't any of those things. Right? Dr. Tobin came back and explained it wasn't carbon monoxide. Right? No. So you know how George Floyd died, and you heard this. But specifically, Dr. Tobin provided fairly extensive detail and was very clear that George Floyd died as a result of a low level of oxygen. This low level of oxygen caused a brain injury and a PEA arrhythmia, which caused his heart to stop. That's not a cardiac event. It's not that his heart disease, right, that didn't cause him to die. It was the low level of oxygen. It was the asphyxia that caused him to die. Right? And we know that happened. We know that happened because they observed during the restraint at 20:24:21, right? What did they observe? They observed an anoxic seizure, right? A telltale sign of oxygen deprivation. Dr. Tobin told you that. Even Dr. Fowler told you that. And after Mr. Floyd experienced a seizure, he passed out. After his pulse stopped, his heart stopped. That cardiopulmonary arrest, that was the result of the police subdual and the restraint and the neck compression. We know from Dr. Tobin, George Floyd did not die primarily from a cardiac event, as has been suggested. Now, George Floyd, he was not in perfect health. Sure, he had narrowed arteries, high blood pressure, no question about that. He was experiencing stress, even before the officers shoved him onto the sidewalk unnecessarily, gratuitously, disproportionately. But none of this caused George Floyd's heart to fail. It did not. His heart failed because the defendant's use of force, the 929, right, that deprived Mr. Floyd of the oxygen that he needed, that humans need to live. And Dr. Tobin knows because he is a pulmonologist. He's a lung doctor. He's a lung doctor. He's also a respiratory physiologist. He's the only person who testified who was able to calculate lung capacity, lung volume. Right? He could do that. Dr. Baker couldn't do it. Didn't do it. He deferred to the pulmonologist, Dr. Tobin. Dr. Fowler couldn't do it. He said he would defer to a pulmonologist. And Dr. Tobin, who also happens to be a critical care physician, he spent years treating patients in intensive care who were experiencing respiratory failure. And Dr. Tobin literally wrote the book on the subject, and he was able to tell you, right, what this looks like, what he was able to observe. What he was able to observe was oxygen deprivation. It was asphyxia. It was asphyxia. Because under the conditions that Mr. Floyd was being restrained, that the defendant put him in, okay, that cut off his oxygen. It would have cut off oxygen of someone who is perfectly healthy, of anyone. The forces that were used in the situation, right, it involved multiple factors. George Floyd was handcuffed. He had impaired arms and chest movement. He was placed prone, shoved prone on the sidewalk. The knees pushing on his neck and back downward. The pavement, the force of the pavement being unyielding. It was like he was in a vice, that he was being, squeezed in a vice. And he calculated, right, between Chauvin, the defendant, Officer King, pushing down on him approximately 90 pounds of force. And the position and the force combined such that it was as if George Floyd's left lung had been surgically removed. That's how much of a reduction of air capacity there was here. To the point that Mr. Floyd was desperately trying to make space to breathe pushing his shoulder, pushing his face against the pavement to lift up, to give space to breathe. His lung capacity, based on Dr. Chaubin's calculation, had just being in the prone position, even though you heard some studies from the defense saying, the prone position isn't dangerous. Well, Dr. Chauvin disagreed. He said that the lung capacity was reduced by 24% just by the prone position, 43% when you consider the additional pressure. So Dr. Chaubin's opinion corroborates the police training and what the police have known for 30 years. Right? That there's a danger to the prone position, and the danger is positional asphyxia. And the danger, the worst thing that can happen with positional asphyxia, is death. And it wasn't just the lungs, the pressing up against the neck. Remember when you touched that it reduced the capacity of airflow such that it was as if Mr. Floyd was breathing through a straw. Right? These shallow breaths did not produce enough oxygen. Not enough oxygen could get to the lungs. And that's what killed George Floyd. And here's what didn't, right? Here's what didn't. This wasn't a sudden cardiac arrhythmia, right? Dr. Smock told you that. Dr. Thomas, Dr. Rich, Dr. Chauvin, they agree. Not a sudden cardiac arrhythmia. That's not how this looks. Dr. Baker, no medical evidence of a heart attack. Okay? We heard from Dr. Rich. Dr. Rich actually treats people who have heart attacks, and he found there was nothing in his review, nothing in George Floyd's heart to suggest that the death originated from the heart. Nothing. Over the course of this case, you heard a lot of things that didn't happen and hypotheticals that don't apply. Right? You know why George Floyd died. You know how he died. You heard a lot about drugs. You heard about his struggle with addiction. There's some things, George Floyd was obviously not a perfect man. Who is? No one is. Right? So you heard about drugs. You heard about drugs in the car, some pills in the car, in the squad car, in his car. You heard questions about, is he chewing gum? Does he have a pill in his mouth based on this free? None of that matters. Because you know what his level, the drug level was. You know that from the toxicology report. Right? If drugs are found in the car, they're not in George Floyd's system. So there's no point in talking about those. Right? Let's talk about what was in his system and the toxicology report. And you heard from Dr. Eisenschmidt, right? And what he testified was that George Floyd's fentanyl to norfentanyl ratio, that the metabolite norfentanyl, that was well below the ratio of people who die from a fentanyl overdose. It was even below the median. And George Floyd's methamphetamine level, that was 94% lower than the group for driving, population for driving under the influence. Right? And Dr. Rich and Dr. Smock, they've treated patients who are under the influence of both fentanyl and methamphetamine, and they testified these drugs did not kill George Floyd. They didn't. We know that he had a tolerance because he used drugs in the past, and the experts all agree, the videos show, that George Floyd did not die the way someone who dies from a fentanyl overdose dies. His breathing, it didn't slow down. Right? He didn't fall asleep. He didn't go into a coma. No. This looked nothing like a fatal fentanyl overdose. Dr. Chauvin, the only doctor in this case who actually calculated George Floyd's respiratory rate, and the best doctor to do so, given his training and given his experience, he stated that the fentanyl in George Floyd's system did not depress his respiration. It didn't. He did not die of a drug overdose. That's not how he died. He didn't die of excited delirium. You heard about excited delirium. Right? Dr. Smock, who testified about excited delirium, told you, explained to you, George Floyd did not exhibit any of the signs of excited delirium, one of which being superhuman strength. Nonsense. There's no superhuman strength. There's no superhuman strength. There are no superhumans. Okay? Impervious to pain. Nonsense. You heard him. You saw him. He was not impervious to pain. It's nonsense. Paraganglioma. Suggestion that this tumor, which is literally called an incidental tumor, relatively rare, maybe causes headaches, that caused his death at that particular moment in time, at that place, after the restraint, after the subdual, after the 9 minutes and 29 seconds, that tumor that causes headaches, that killed him? No. That's just a story. And Dr. Rich specifically testified that he looked in George Floyd's medical records and he did not find references to headaches. And you heard about carbon monoxide. The car killed him. Well, Dr. Chauvin came back and explained, right, this car, which had a catalytic converter, that was outside, that was a hybrid, and there's no evidence was even on, right, that did not kill him. Right? He explained carbon monoxide saturation level, oxygen saturation level, and based on his calculation of oxygen saturation level at 98%, right, at most there could have been a 2% carbon monoxide, same as anybody else, same as people walking around, talking, breathing. Right? This wasn't carbon monoxide. That's just a story. And it's simply wrong. You don't have to be Dr. Chauvin to recognize this. It's probably nice to be Dr. Chauvin, but you don't have to be Dr. Chauvin to recognize this. You can see this with your own eyes. You could see what happened, that he couldn't breathe. He said he couldn't breathe. The defendant was on top of him, on his back, on his neck, with his knees pressing down. Of course. You saw how his body just sort of deflated into the ground, past the point of consciousness. There were multiple moments in time, ladies and gentlemen, multiple moments in time that things could have gone different, and George Floyd would have lived. CPR. If he would have left him in the side recovery position in the first place, or just placed him in the side recovery position shortly after the restraint, wouldn't have died. Their own force witness testified that putting somebody in the side recovery position is pretty fast, pretty easy thing to do, not complicated. No. Professor Stoughton said you just rotate them 90 degrees, quick. Could have done that, relieve the pressure. Could have done CPR, chest compressions. Was supposed to, had a policy he was supposed to follow. Right? A duty to provide medical aid. You're not just supposed to phone that in. You're actually supposed to use your training, provide the medical aid. Even Dr. Fowler was critical. No one starting CPR. Said that should have been done. Defendant knew how to do it. He had the training. He knew better. He just didn't do better. George Floyd didn't have to die that day. Shouldn't have died that day. But for the fact the defendant decided not to get up and not to let up, George Floyd died. And these actions were a substantial factor in George Floyd's death. And these actions, make no mistake, these actions were not policing. These actions were an assault. So, as the judge instructed you, for second-degree murder, and it's actually very simple, if you find that the defendant committed this third-degree assault, while committing the assault, he caused George Floyd's death, defendant's guilty of murder. That's the way felony murder works in Minnesota. So there are two elements. Right? But the defendant assaulted George Floyd. And what does that mean? Assault is the intentional infliction of bodily harm upon another, or the attempt to do so. Intentional infliction of bodily harm, that requires proof that the defendant intentionally applied unlawful force to another person without that person's consent, and that the act resulted in bodily harm. Okay? Intentional. Did it on purpose. He did the thing on purpose. Bodily harm, physical pain, illness, or impairment of a person's physical condition. So again, to be very, very clear, the state does not have to prove that the defendant had an intent to kill George Floyd. This was an intentional act that you see before you. He did this on purpose. And that's clear. He didn't, again, trip and fall and find himself there. And this was also unlawful force. Officers are only authorized by law to use reasonable force. And this was not reasonable force, as I'll explain. And George Floyd clearly did not consent to having the defendant's knee on top of him for 9 minutes and 29 seconds. When you hear someone gasping for breath, calling for their mother, begging you to get off, how could you think anything else? That he did not consent to this. Now, the state does not have to prove, what we don't have to prove about intent, we don't have to show that the defendant intended to cause George Floyd harm. We don't have to show that. You don't need to find that the defendant was trying to cause harm or had the purpose to cause harm to conclude that this was an assault. You do not. The state doesn't have to show that the defendant intended to violate the law. We don't have to show that. We don't have to show that the defendant intended to kill him. The only thing that the only thing about defendant's intent that we have to prove is that he applied force to George Floyd on purpose, that this wasn't an accident, and it's pretty simple. You know, if you're doing something that hurts somebody and you know it and you keep doing it, you're doing it on purpose. Somebody's telling you they can't breathe and you keep doing it, you're doing it on purpose. What else is going to happen when you push somebody down on the pavement? Everybody knows this. Everybody knows what happens when you push somebody against the pavement. Right? You learn this pretty early on. We learn this pretty early on. Assault in the third degree requires that the defendant inflicted substantial bodily harm on George Floyd. Right? Substantial bodily harm meaning a temporary but substantial loss or impairment of the function of a bodily member or organ. Organs, the lungs, the heart. Temporary loss of consciousness qualifies as substantial bodily harm. Certainly a permanent loss of consciousness could constitute substantial bodily harm. You look at this point in the restraint and you see the absence of expression, the absence of muscle tension. He's unconscious. He's lost consciousness. That's substantial bodily harm. He did that. That's his knee. So when you consider the charge of second-degree murder, try to break it down into parts and find an order. The defendant caused George Floyd's death. He did. The state proved that beyond a reasonable doubt. And at the time of causing the death, the defendant committed or was attempting an assault in the third degree. And that's been proved beyond a reasonable doubt. With those being proved in the venue, right, second-degree felony murder, the defendant is guilty. So going back and talking about murder in the third degree, you can see that there's some elements in common. Right? There's some differences. We've already discussed the first element, the death of George Floyd, the substantial causal factor with the second element, and then the fifth element, about the venue element, I'll call it, May 25, 2020 in Hennepin County. So for third-degree murder, the difference for third-degree murder is that the defendant had to cause George Floyd's death by committing an act that was eminently dangerous and performed without regard for human life. And again, the state is not required for this charge either to show that the defendant intended to kill George Floyd, that he committed an act that was eminently dangerous and performed without regard for human life. And it must prove, the state must prove that the act was highly likely to cause death, that the defendant acted with a reckless disregard for human life, that he was consciously indifferent to loss of life that his actions could cause. The defendant's act was eminently dangerous to others. It was likely to cause death to Mr. Floyd. And as if common sense in and of itself would not suffice, the dangers of prone restraint, of positional asphyxia, has been known in the law enforcement community for about 30 years. Right? This is known, if common sense wasn't enough. Defendant's own use of force witness admits that. And again, when we talk about danger, what is the danger? What's the potential danger of positional asphyxia? It's death. Right? The medical experts who know a few things, who know a thing or two, right? Dr. Tobin, Dr. Smock, Dr. Rich, they agreed. Okay? The defendant's actions created a high risk of death. And the defendant consciously disregarded the loss of life that his actions could cause and did cause. He knew the risks of positional asphyxia due to this position. Everybody in law enforcement knows that, but he had other warnings, not just from his training. He had other warnings from people.
He's ready to resist an arrest right now, bro.
Pass out.
That's what happens on the ground. He's breathing right now, bro. You think that's cool? You think that's cool, though, right? What's your badge number, bro? You think that's cool right now, bro? You think that's cool, though, bro? You're a bum, bro. You're a bum for that. You're a bum for that, bro. You think you getting mad? You just sitting there stopping his breathing right now. The dude's about to go out right now, bro.
Right. It was plain and apparent to everyone who was there what was happening. He's going unresponsive. He's passed out. He's not talking. What are you doing? Now, we know that the defendant chose not to listen to bystanders, not to these bystanders, but how about to fellow officers on the scene?
Roll him on the side.
Roll him on his side, staying put where we got him. That's what the defendant said. He's staying put where we got him. Roll him on his side means roll him into the side recovery position. He could have listened to the bystanders. He could have listened to fellow officers. He could have listened to his own training. He knew better. He just didn't do better. He knew that kneeling on somebody's neck, in addition to the positional asphyxia, just the pressure, is dangerous. Anyone can tell you that. A 9-year-old can tell you that, did tell you that. Conscious indifference? Indifference? Do you want to know what indifference is and sounds like?
I'm through. I'm claustrophobic. My stomach hurts. My neck hurts. Everything hurts. There's water or something. Please. I can't breathe, officer.
Hey, a lot of talking, a lot of yelling.
They will kill me, man.
Takes a heck of a lot of oxygen to
Come on, man.
Indifference. Leisurely picking rocks out of the tire, commenting about the smell of the man's feet who you're pressing down, grinding on. as his voice slows and fades as he tells you, "You're going to kill me. I can't breathe. My stomach hurts. My neck hurts. Everything hurts. It takes a lot of oxygen to complain about it. Indifference. Did the defendant ever listen? Ever consider medical attention? No one defended that decision, the failure to give CPR, not even Dr. Fowler. This isn't protection. This isn't courage. And it certainly is not and was not compassion. It was the opposite of that. So back to the instructions and the elements of third-degree murder. When you're deliberating, ask yourselves, did the defendant cause the death of George Floyd by an intentional act that was eminently dangerous to others? Absolutely. The state proved that. Did the defendant act with a mental state consisting of reckless disregard for human life, a conscious indifference to the loss of life that the eminently dangerous act could cause? Yes, he did. And you will find, based on that the state has proved the defendant is guilty of third-degree murder as charged. So back to the charges, let's talk about manslaughter in the second degree. And again, you can see that there's some elements in common. The first, the third is in common with the other charges. So what's different about manslaughter in the second degree is that the defendant caused the death of George Floyd by culpable negligence. Culpable negligence, where created an unreasonable risk and consciously took a chance of causing death or great bodily harm. And again, we do not need to prove, the state does not need to prove that he intended to kill George Floyd. Culpable negligence, intentional conduct, that the defendant may not have even intended to be harmful, but that an ordinary and prudent, reasonably prudent person would recognize as involving a strong probability of injuries to others. You can look for yourself and you can see exactly what was happening. The bystanders who were at the scene looked for themselves and it was plain to them. They took video, you saw it, it was plain to you. Strong probability of injury. And with the defendant, his specialized knowledge about the dangers of positional asphyxia and the common sense that if you put your knee on somebody's neck, there's a strong probability of injury, he knew that too. Great bodily harm, bodily injury that creates a high probability of death. Permanent or protracted loss or impairment of the function of a bodily member or organ. The heart, the lungs, the loss of consciousness. Would an ordinary and reasonably prudent person know that this is dangerous? Everybody who watched knew it was dangerous. A 9-year-old saw that it was dangerous. And the defendant knew exactly what he was doing because he was right on top. He was right on top of him. But his negligence goes beyond his intentional assault of Mr. Floyd. His negligence includes his failure to act. In your custody means in your care. In your custody means in your care. There is a duty to provide medical assistance. That duty includes not only calling the ambulance for somebody else to do, it means that you have to use your knowledge, your training as a first responder. You're required to perform CPR. It's a requirement. He failed to do it. He had the training. He knew how to do it. You've seen his training records. It's Exhibit 119. You can take a look at all of the in-services, all of the hours. Right? He knew what to do. He just didn't do it. He knew better. He didn't do better. He wouldn't even let Genevieve Hansen, the off-duty firefighter, do it. If he wasn't going to do it himself, he would let somebody else do it. But he didn't. He had the knowledge, he had the tools, he just ignored it. So when you consider this charge, that the defendant caused George Floyd's death by culpable negligence, where he took an unreasonable risk and consciously took a chance of causing death or great bodily harm, you will find that element has been proved beyond a reasonable doubt, that he is guilty of second-degree manslaughter, guilty of all three charges. So, after all of this, you have another question you have to address. After seeing all of this, finding the assault, finding the murder was committed, the manslaughter was committed, you have another thing to consider, and that is, was this just okay? Was this fine? Is this okay because the defendant was a police officer? Was this an authorized use of force? Was it justified? Was it justified? It was not. Let's look at the instruction of the kind and degree of force a police officer may lawfully use in executing his duties. It's limited by what a reasonable police officer in the same situation would believe to be necessary, and force beyond that is just not reasonable. You look at the facts that a reasonable police officer in the same situation would have known at the precise moment that the officer acted with force. Right? Looking at all of the totality of the facts and circumstances to see whether these actions, the defendant's actions, were objectively reasonable. Was this objectively reasonable? No. We just saw the instruction that the law does not provide an excuse for police abuse. It does not. Let's start with the most basic of premises, because that's very important. That restraining George Floyd in this manner, on the ground, prone, handcuffed, knee on the neck, knee on the back, body weight on top of him, start with the premise that that in fact was a use of force. The defense called a witness who actually testified that that was not a use of force because that is not likely to produce pain. No. No. Not true. Likely to produce pain, actually produced pain. You know, the problem with terms like superhuman strength, you forget that those people don't exist. Humans feel pain. Human beings feel pain. Human beings need to breathe. Don't accept any notion to the contrary. You need to reject that testimony. You need to reject it. And let's discuss the standard. What would a reasonable police officer do? Okay? What would a reasonable police officer do? You don't look at this from George Floyd's perspective. Okay? It's not what a reasonable victim would do. You don't look at it from the bystander's perspective. What would a reasonable bystander do? But under the law, you don't look at it from the defendant's perspective either. You look at it from the perspective of a reasonable officer. And the evidence in this case has shown over and over that the defendant is not that officer, because he did not act as a reasonable officer would. Remember Charles McMillan? Right? Well, the defendant explained his actions. He explained the basis of his actions to Charles McMillan. You recall that. Here's what he said.
Yeah, and I tried to get in the car.
Looks like he's probably on something.
That was his justification for using this level of force. He's a big guy. He's a sizable guy. He might be on something. We have to control him. Control is the restraint. So that's the force. Okay? His two justifications were that George Floyd was big and that he might be on something. Well, you know the standards. You've heard the standards many times. You know the difference between a risk and a threat. Officers are authorized to use force to respond to a threat. They're not authorized to use force to respond to a risk. Anybody poses a potential risk. Big, small, in between. Everybody's a risk. Not everybody's a threat. Being large, the act of being large, it's not a crime. It's not a risk. Sorry, it's not a threat. It's merely a risk. Being on something, it's not a threat. It may be a risk, but it's not a threat. And force is not authorized against someone merely because they're on something. And when questioned, their force expert, witness, conceded that the combination of the two, being large and being on something, is not a justification for the use of force. It just isn't. That's not what they get to do. Right? So the defendant's entire basis, his explanation to Charles McMillan at the time, at the scene, right afterwards, after he got up off of Mr. Floyd and tossed him onto that gurney and walked away like it was nothing. That was his explanation. It's not good enough. It's not procedure. It's not the use of force policy. It's not following the rules. Now, we talked a lot about things that might have happened, could have happened, potentials, hypotheticals. Talked about a lot of stuff that didn't happen. Right? You need to focus on what did happen. What did happen. George Floyd was not a threat. He never was. He wasn't resisting. He just wasn't able to comply. They should have recognized that. They should have recognized that. They do it all the time. They had him handcuffed. They had plenty of resources. They had 4 officers. They had a 5th one off in the distance. He was handcuffed behind his back. He wasn't going anywhere. Right? He wasn't doing anything. He didn't need to be put in the prone position. That's a temporary position to facilitate handcuffing. But the defendant was on top of him, stayed on top of him, grinding his knees into him, pressing down on him, continuing to twist his arm, twist his wrist, so it would buck up against the handcuff. A pain compliance technique without the opportunity to comply is simply the infliction of pain, not a reasonable use of force. And that's not authorized by the Minneapolis Police Department. Kneeling on top of someone, on their neck and their back, effectively they were using a maximal restraint technique. Effectively. Remember the hobble, the rip hobble? You heard about that? They considered using it. They thought about using it. Decided not to. They didn't need to, right? Because it wasn't doing anything that would warrant it. But if you're going to restrain someone like that completely, holding them down, the policy authorizes the use of the hobble, the rip hobble. Right? They didn't do that. The policy about applying the rip hobble is, again, you have to put the person immediately in the side recovery position. You know, why didn't they do that? Right? The conduct didn't warrant it. They knew it. They didn't want to have to get a sergeant down there to do a force review. It's Memorial Day. Right? You heard that comment. They talked about that. So they just held him in this dangerous position against policy. A reasonable officer wouldn't do that. A reasonable officer follows the rules. A reasonable officer follows the training. Force that carries a risk of death is deadly force. And you recall the MPD Defense Tactics and Control Guide. Like, deadly force is just not authorized in this situation. No force. When someone is passed out, on the ground, unresponsive. No. You really can't even claim that Mr. Floyd was engaged in passive resistance. At this point, remember Charles McMillan? He kept saying, get up and get in the car. Get up and get in the car. And George Floyd said, I will. I can't. He doesn't even have the opportunity. He's saying he'll get up and get in the car. He isn't given the opportunity to do that. That's not resistance, that's compliance. At least an attempt to comply. Force must be reasonable. It must be reasonable at the point it starts, at the point it ends, and all points in between. Officers are required to reassess the situation, to reevaluate the situation, to take in the information and react to it. The defendant didn't do it. The defense has made the argument that the crowd justified the defendant's use of force, like the blame should fall on the bystanders for displaying concern over a man's life. What? But this was a distraction, that there was some concern. The defendant doesn't appear too concerned. It wasn't the bystander's fault. A 19-year police veteran, a field training officer with over 800 hours of training, should not be distracted by the comments of a 17-year-old or being filmed by some civilians. There's a policy about filming. They understand that civilians can film them. Right? They know that. It's right there. This isn't something new or earth-shattering or even particularly noteworthy. Sergeant Steiger, you recall him from LAPD. He used to patrol on Skid Row. He talked about people throwing rocks and bottles. They have a phone. They have phones. They're expressing concern. They're not doing anything. This is not a justification for an assault, for murder. Defense suggested in their cross-examination that reasonable minds can disagree, or that some of the witnesses don't line up exactly where the force began or what exactly should be done, but don't get caught up in that. Don't miss the forest for the trees. Okay? Consider the testimony as a whole. Officer after officer after officer got on that stand, raised their hand, and told you, the chief of police, right, that this conduct, the 929, violates the use of force policy, violates the department's core values. He violated his duty of care. He failed to render aid. Remember, Commander, now Inspector Katie Blackwell, who was in charge of all training, looked at this and said, I don't even know what this is. I don't know what this modification is. This isn't how they train. These aren't the rules. Lieutenant Mercel looked at this and he said, without equivocation, not an MPD trained tactic. It is not. We don't train our people to do this. You can present 1,000 hypothetical situations. You can talk about what didn't happen all day long into next week. But when you talk about what did happen on that day, at that time, that's what they said. Use of force, unreasonable. Supervisor, Sergeant Pluger, the force should have ended right after Mr. Floyd was on the ground. His supervisor said that. Lieutenant Zimmerman, the oldest serving, or I should say the most years of service on the Minneapolis Police Department, longest serving, correct myself, longest serving member of the department. What did he say? He looked at this. He said this was totally unnecessary. Totally unnecessary. A use of deadly force. Not reasonable. Only reasonable force is authorized. Sergeant Steiger, expert witness, Los Angeles Police Department. He's trained thousands of police officers. He looked at this. This is objectively unreasonable force. Professor Stoughton, former police officer, University of South Carolina Law School professor. This use of force was unreasonable, it was disproportionate, and it violates national standards. The experts agree. Because the force has to be reasonable when it starts, it has to be reasonable when it ends, And what is happening? If you look at the bottom, George Floyd is handcuffed and on the ground. Right? What is he saying? He's saying, I can't breathe 27 times within the first 4 minutes and 45 seconds of this encounter. He's saying that. And the defendant continues to kneel on his back and neck, continue the dangerous restraint. George Floyd says, into the restraint at 8:22:24, my stomach hurts, my neck hurts, everything hurts. Defendant heard that. He heard those words. Was George Floyd resisting when he was trying to breathe? No. No. And the defendant heard it, and he acknowledged it, and all he did was mock him. It takes a lot of oxygen to complain. That's what he said. It takes a lot of oxygen to say that. When George Floyd gave his final words to the defendant, please, I can't breathe. I can't breathe, crying out for help by the man in uniform. The defendant stayed right on top of him, ignored it. Continued doing what he was doing, facing the crowd, grinding his knee, twisting his hand. I think he's passing out, Officer Lane says. Officer King can't find a pulse. Now, the greatest skeptic of this case among you, how can you justify the continued force on this man when he has no pulse? No pulse. Continued the restraint, continued grinding and twisting and pushing him down and crushing the very life out of him. It wasn't too late. He could have rolled him over, performed CPR. No, he continued. Past the point of finding a pulse, past the point where the ambulance arrives, past the point where the EMTs get out of the ambulance. What's the goal? What's the plan here? What are we trying to accomplish? This was a counterfeit $20 bill, allegedly. Right? What is going on? Why hold him that long, past that point, past that line that was crossed? No. Unreasonable force. Unreasonable. Not proportional. Excessive. It violated policy, it violated the law, it violated everything that the Minneapolis Police Department stood for. It is not lawful. I use that phrase, awful but lawful. Right? But force that is not lawful, it's just awful. So the defendant is guilty of second-degree murder. He's guilty of third-degree murder. He's guilty of second-degree manslaughter. All of them. Because this was not a justified use of force. You cannot justify this use of force. It's impossible. Not if you apply the rules, not if you apply the standards. That a sworn officer to protect and serve, but a sworn officer, that oath that they take. You know, at the beginning of my comments, I talked about George Floyd's life, how he was surrounded by people who cared about him, surrounded by familiar faces, people he could look out to in the crowd. That at his death, he was surrounded by strangers. They were strangers, but you can't say they didn't care. You can't say that. These people were randomly chosen from the community. People from the community randomly chosen by fate. And they were coming from different places, and they were going to different places, and they had different purposes. All of them. Random members of the community. All converged by fate at one single moment in time to witness something. To witness 9 minutes and 29 seconds of shocking abuse of authority. To watch a man die. And there was nothing they could do about it because they were powerless. They were utterly powerless because even they respected the badge. Even seeing this happening, they cried out at first, pointed out, hey, you can get up off him. It became more and more desperate as they watched us go on and on and on, and there was nothing they could do. All they could do was watch and gather what they could. Gather their memories, gather their thoughts and impressions, gather those precious recordings. And they gathered those up and they brought them here. And they brought them here and they got up on the stand and they testified and they bore witness to what they saw. They bore witness to this outrageous act and they told you about it and they gave you what they had. Their thoughts, their impressions, their memories. They gave you those precious recordings so you can see this. You can see this from every single angle. They gave that to you. They were powerless to do anything but that. They gave it to you. Randomly selected people from the community. You got a summons in the mail. And here you are. All converged on one spot. Now, our system, we have power. The power actually belongs to us, the people. And we give it to the government in trust for us to hold and to use appropriately. But sometimes we take it back. Sometimes when something is really important, we reserve those decisions for ourselves. The state, we have power. We cannot convict the defendant. The judge has power, but he cannot convict the defendant. That power belongs to you. You have that power, and only you have the power to convict the defendant of these crimes, and in so doing, declare that this use of force was unreasonable. It was excessive. It was grossly disproportionate. It is not an excuse for the shocking abuse that you saw with your own eyes. And you can believe your own eyes. This case is exactly what you thought when you saw it first, when you saw that video. It is exactly that. You can believe your eyes. It's exactly what you believed. It's exactly what you saw with your eyes. It's exactly what you knew. It's what you felt in your gut. It's what you now know in your heart. This wasn't policing. This was murder. The defendant is guilty of all 3 counts. All of them. And there's no excuse. Thank you.
Members of the jury, we're going to take a 20-minute break, and just for your information, we'll also take a 20-minute break after the defense argument, before the state's rebuttal and the final instructions.
All right, you have been listening to Hennepin County Court. We've been listening to closing arguments in the case of Derek Chauvin, the former police officer accused of killing George Floyd. Let's recap some of this. Let's bring in NBC News legal analyst Joyce Vance. She's a former U.S. attorney. She's a professor at the University of Alabama Law School, and she's been watching all of this with us. Several things I found notable. I mean, essentially, this was the prosecution saying, believe your eyes. You saw the tape. What happened there was that George Floyd died from a lack of oxygen. I also thought it was really interesting how many times the prosecution said this is not about policing. This is not about the police force. This is about one man's actions. He said he's not on trial for being an officer. He's on trial for what he did. That is a strategic argument.
That's absolutely right. The prosecution wants to avoid any possibility of a member of the jury thinking that they're targeting policing written large. And so the prosecutor was careful to say, you know, this is the state of Minnesota versus Derek Chauvin, not versus the Minneapolis Police Department. And he closed by saying very powerfully, this wasn't policing, this was murder, encouraging the jury to draw that distinction.
And talk briefly, Joyce, about what this jury is going to have in front of them. Next, we'll hear from the defense, and then there will be a rebuttal. But eventually, this will go to the jury.
It will, and with them, they'll have access to evidence, to videotapes. Very importantly, they'll have access to the judge's jury instructions, which explain the law that they're supposed to use in evaluating the facts. You know, this is a difficult process, and I think for those who stuck through this entire closing argument by the prosecution, you get a sense of just how much evidence there is here that has to be considered and that has to be reconciled because all of it's not consistent. Even sometimes prosecution witnesses have different ways of saying things. So the prosecution closing argument is their first shot to talk with the jury about what the evidence means. Up until this point, the jury has been hearing the evidence as it comes in on direct examination, on cross-examination, and now the prosecutor looks the jury in the eye and tells them, here's the law that the judge has explained to you, here's why our evidence establishes guilt beyond a reasonable doubt. And the jury can review that evidence, and I suspect that they will very carefully as they deliberate before they reach a verdict on each of the 3 charges against Derek Chauvin.
All right, stand by. Let me go to NBC's Gabe Gutierrez. He's been following this trial all along. He joins us from outside the Hennepin County Courthouse, where those arguments have just been underway from the prosecution. Gabe, I wonder if you can walk us through what's going to happen the rest of today, but also the significance of this trial and this moment. It goes far beyond Minneapolis. It's going to affect the whole country.
Yeah, Kate, that's exactly right. And as Joyce mentioned, the prosecution went through great pains just now to talk about how this is not an anti-police prosecution, but that it is a prosecution on the actions of one man, Derek Chauvin. But what is significant, Kate, and what we've been hearing really from across the country is how significant this trial in how police officers testified against one of their own. We saw cop after cop take the witness stand, including the police chief of Minneapolis, and talk about how Derek Chauvin went too far. And the prosecution brought that up in its closing argument. You saw one graphic, a prosecution exhibit that had 7 police officers all saying in various degrees how Derek Chauvin not only violated policy, but in the prosecution's view, violated the law. This is something that will be closely watched really across the country, even as protests are unfolding not far from here in Brooklyn Center, Minnesota, but also in Chicago and in communities across this country, as all eyes are on Minneapolis. There has been a lot of attention paid to the so-called blue wall of silence, how many police officers do not testify against their own, and that so-called blue wall seemed to be crumbling during this trial. Reverend Al Sharpton and the Floyd family at the beginning of this trial, right before jury selection, talked about how the American policing system was on trial, although both the prosecution and the defense have really stressed that this is really about Derek Chauvin and his actions. But talking about what we expect to see for the rest of the day, as you said, after this break, the defense will come in and give its closing arguments. Then we expect the prosecution to give the rebuttal. It is possible as well that the judge can give a few more brief jury instructions before this is handed off to the jury. The jury will then be sequestered while it discusses and debates among themselves the charges against Derek Chauvin. Kate.
And Gabe, what do we know about this jury? You know, who are they?
Right. Well, right now there are 14 members of this jury. 2 of them will be dismissed. There will be 2 alternates. As of now, I believe that there are 8 white jurors, 4 black jurors, 2 of mixed race. And they went through a very extensive jury selection process, Kate. And one of the main questions in their jury questionnaire was their views on Black Lives Matter and Blue Lives Matter. This was a theme that really has been brought up very much during this trial from the very beginning. Both the prosecution and the defense wanted to get jurors' thoughts on how they felt about those two movements. I was in the courtroom last week and was able to see these jurors in person. Of course, they are not on camera, and they will remain anonymous during these entire proceedings. But I was able to gauge their reactions. It's difficult because of COVID protocols. They have masks on, so you can't see their reactions, for example, when a witness is testifying. But I did notice that they all seem extremely engaged during the witness that I saw, a cardiologist. During certain parts of the testimony, many of them, almost all of them, would go and take notes and seem very engaged for even technical medical terminology. So it's hard to get into their minds. They at least seem to know the weight of this moment, the weight of this trial, and seem to be paying extremely close attention. Of course, the question will be, how long will the deliberations take? That's impossible to predict in a trial like this. But again, there are 14 jurors right now. 2 of them will be dismissed as alternates, and they will begin deliberations presumably within the next few hours, Kate.
All right, Gabe, thank you. And they must know that the eyes of the world are on them right now. I want to go to former Seattle Police Chief, NBC News law enforcement analyst Carmen Best is with us as well. Picking up on what we were just talking about with Gabe and the question of use of force, appropriate use of force. Gabe mentioned all the officers, including the chief of police in Minneapolis, who testified for the prosecution, describing the use of force by Derek Chauvin as excessive, as inappropriate. What do you think of that argument that you just heard in the prosecution's closing argument?
I think the prosecution did a really good job of highlighting the fact that they have to utilize the reasonable officer standard. And there were multiple officers, up to and including the police chief, that said this simply was not reasonable, what he did. Leaving his knee on the neck and back of George Floyd for over 9 minutes was excessive. It was outside of policy, and it was not reasonable. And that point needed to be driven home and made very clear. I thought it was made exceptionally clear by all the people who came forward to talk about the policies, the training, the practices. And clearly, no one trains people to leave someone in duress like that for over 9 minutes without doing anything to safeguard their safety, without putting them into the recovery position. And I'm sure that as the officers and the chief are watching this, that they are glad that they came forward in the manner that they did, and very concerned. Even though policing itself is not on trial, we do know, as you've noted, that the world is watching and that people will be wanting to see justice served here. And if not, certainly, they're going to be really concerned about, the aftermath once the verdict is reached. So I know that's what I would be thinking of if I was the police chief there. And I've been a chief, but I know these are the concerns that you have. How are you going to maintain public safety when you are right now the focus of such a potentially volatile situation?
Yeah, and Gabe mentioned preparations underway in Minneapolis and many cities across the country right now, just in case.
Yeah, that is correct. There have been situations. This has been a really tough week for law enforcement. It seems like every day we have seen something that took us to a new low. And now we have this case that is so critically important with national, international attention. And absolutely, law enforcement and officers all across the country are going to be really trying to prepare for what might occur. Obviously, none of us is clairvoyant and knows what the outcome is. Everyone's hoping for justice to be served. But then they have to also consider, as we did in Seattle, protecting facilities, protecting the officers. You have a responsibility to do that as well, protecting community and property and life safety, which means that you have to be prepared with as many resources as possible. It doesn't look pretty, but also those things have to be taken into consideration.
All right, Carmen Best, stay with us. Thank you. Just to recap, and if you're just joining us, we are in a brief break right now in the Derek Chauvin trial in Minneapolis. That's, of course, the former police officer accused of killing George Floyd. We heard from the prosecution, more than an hour and a half closing argument from the prosecution, Steve Schleicher presenting their case. What we expect to happen after a 20-minute break, and we're maybe about 10 minutes or so into that right now. We expect to then hear from the defense. The defense will have their opportunity to present their closing arguments, and then after that, a rebuttal from the prosecution. And at that point, the jury would be instructed by the judge and would get this case and start their deliberations potentially today, although we don't know what the timing is for all these arguments. Let's turn to criminal defense attorney, NBC News legal analyst Danny Savalos, who's been watching along with us as well. Danny, given what the prosecution just did in that hour and a half, what does the defense need to do next?
Look for the defense to take a calm, measured approach, a lot like the prosecution, and ideally have some demonstrative exhibits like that very effective chart that the prosecution had, and hammering home their themes. No surprises in the prosecution's closing. They should stick to the plan, and the plan is attack on causation and attack on the idea that the neck compression and restraint was not only not eminently dangerous, not a felony, but it's something that was taught and acceptable, and rely on your own use of force expert, the defense's expert, who said that this was something that was acceptable. Really stress your own medical expert, your own scientific expert who attacked causation for the prosecution, but more than that, rely on Dr. Baker, the prosecution's own expert, the medical examiner, who, not surprisingly, the prosecution sandwiched between a bunch of other experts that gave the prosecution evidence they liked better. And the reason for that was the actual medical examiner, the only person to put hands on George Floyd, gave some testimony that was good for the defense. Expect him to feature prominently in the defense's closing, but they will stick to the plan. They will hammer home causation. They will say the state has not proven beyond a reasonable doubt that Derek Chauvin's knee was a substantial factor in George Floyd's death. Then they will go to the training and argue that the restraint, as it was not eminently dangerous, was not a felony. There's nothing much to change in the plan, but look for the prosecution, as calm as they were in the beginning, because they get that final word. That's when the prosecution might start breathing fire and brimstone and be a lot more animated. Look for that at the very end after the defense is closing.
And I'm sorry, I was trying to jump in because I wondered about what we were just talking about with Carmen Best, with the former Seattle police chief, the wall of blue, the fact that you had the chief of police and several officers testify that it was inappropriate to use that much force. How does the defense counter that right now for the jury? I mean, what do they say about that?
All they can really do is make some paper cuts there. And by that, I mean point out that, for example, the chief hasn't arrested anyone in so many years, for example, or that they were not physically present, weren't there in the scene. They can't take into account all the other contextual features that even the video doesn't capture. That's what the defense will have to argue. Look, the video is the strongest piece of the prosecution's evidence. The defense's challenge is to get the jury's attention away from the video and start thinking about what's not on the video, which is, blood levels of fentanyl, methamphetamine, and George Floyd's poor health, most of which you can't see from the video. The defense needs to make that clear, either through their experts or through other scientific evidence. Look for them to push that and not rely on video at all, because most of the video is bad for the defense.
And Danny, in terms of the charges, if you saw the prosecution with their chart trying to guide the jury and say, check this box, check this box, they've fulfilled, the prosecution argues, every element needed to convict on all three charges. What will the defense argument be about how will they blow holes in those?
Really effective for prosecutors to walk jurors through, almost like you're building a model airplane. And the case, there's, well, what do we do now? And sitting down and essentially talking them through that, giving them a guide for going through the jury instructions is very effective. And it's jurors through those essentially PowerPoints can be very, they know that their duty isn't to build a case the way the prosecution does, but chop away at particular elements. That a death happened, for example, or that it happened in Hennepin County. But obviously, they're going to attack one or two elements that they think they have the strongest case against. And of course, causation hits all of those crimes, and also justification that the neck compression and subdual restraint was somehow justified. And you saw the prosecution anticipate that and try to nip that in the bud before the defense gets up. But the defense has to stress those two major points, because if the jury believes that Derek Chauvin did not legally cause the death, that is to say, he did not set facts in motion that caused the death, he wasn't a substantial factor, that's a defense, for example, to all charges, as is justification on the use of force, a defense to all charges. So look for the defense maybe not to use such an explicit demonstrative exhibit and go through each and every element, but instead to think broader, big picture. Causation is a defense to absolutely everything. If you find he didn't cause death legally, that is, then you must acquit. Similarly, if the force was authorized or justified, or at least not a felony and not imminently dangerous, then you must acquit as to these charges. He'll still walk them through the elements, but maybe in a less meticulous manner, because that's not the defense's burden.
All right, Danny, thank you. Stand by for us. I want to just recap the prosecution's closing arguments. If you're just joining us, it was more than an hour and a half that attorney Steve Schleicher got very personal, in visceral detail, described George Floyd's anguished final moments.
Just a human, just a man, lying on the pavement, being pressed upon, desperately crying out. A grown man crying out for his mother. A human being.
Mary Moriarty is the former chief public defender for Hennepin County, Minnesota. That's the Minneapolis area. That's the area where this courtroom is. Mary, you've been watching all of this. You know, I'm sure, all of the players involved here. What were your thoughts on the prosecution's closing argument?
He started out by saying his name was George Perry Floyd. And I think that centered all of us into what this case is really about. So it was a really effective opening line. And he went on to talk about George Floyd being surrounded by family all of the time. And he ended by talking about him being surrounded by people who bore witness to what happened to him. So he started out really well. He ended really well. I think it bogged down a little bit in the middle. It was a little too long, but I understand there's a lot of information he was trying to get out. There were themes he mentioned over and over. You can believe your eyes. He knew better, but he didn't do better. So I think it was pretty strong. It covered the bases. They also got really favorable jury instructions from the judge. And I think those are going to make a big difference. And one example of that is that the defense asked, go ahead, sorry.
I was just going to say, how do you mean? Because for us, for non-lawyers, there were a lot of instructions to the jury, a lot of detail. How do you mean it was favorable?
One of them was that the defense had asked for the 20/20 hindsight instruction, which other judges have given in police officer shootings. For instance, in the Yanez case with Philando Castile. And what that instruction says is that you look at it from a reasonable police officer's point of view without 20/20 hindsight. And so the 20/20 hindsight instruction, I think, puts the jury in a bit of a box in that they don't want to second guess officers because they weren't there. And we've heard the defense try to argue that throughout the case, but they will not get that instruction. The defense also asked for a different instruction on causation. They asked for the judge to instruct the jurors that George Floyd's heart, the drug use, that sort of thing was a superseding cause. He did not do that. In fact, he kind of went the opposite and said that superseding causes had to be the cause of death. And so the jury would have to find that the heart, anything else that the defense raised, was the cause of death, whereas the state simply has to prove that Chauvin's actions were a substantial cause of death or started the chain reaction that led to his death. So the specific instructions they got were very favorable for the state.
All right. Mary Moriarty, former chief public defender right there in Hennepin County. She'll stay with us as well. I do want to let people know that we're about a minute or two away from the end of the 20 minutes that the judge had said they would take. He had said they would break for 20 minutes and then come back for the defense presentation of their closing arguments. We're continuing to monitor the courtroom, obviously, and as soon as we see activity, we'll go back to that. But for the moment, let me bring in civil rights lawyer and former prosecutor David Henderson, who's with us. Let's talk about the video that we saw. The prosecution really did rely on showing pictures and frankly, very disturbing video. We've all seen it. But, you know, it's difficult to watch again. Do you think that was effective?
Kate, I do believe that's effective because that's the primary vehicle that's driving the prosecution's case. And what I think it's important to remember is, whereas we've been having conversations about the case every evening, talking through how the case is going to develop, today is the first day the jury might begin deliberating about everything they've seen. So it's really important to use that video to remind them about that strong emotional content. When you're giving a closing argument like this one, especially when it lasts so long, you want to have what I call sticky communications, things that stick in people's minds that they'll refer back to during jury deliberation. An hour and 40 minutes may not seem like a lot, but when you combine that with the amount of time that Judge Cahill spent giving the instructions, you're approaching the length of a movie. And whenever you talk for that long, past the length most people can sit through a sermon, you run the risk of people having a really difficult time focusing on what's most important.
All right, David Henderson, thank you so much. Stay with us as well. I want to bring in Eugene Robinson. He's a Washington Post columnist and NBC News political analyst. If you've been with us all morning, I interrupted you earlier, Eugene. I'm sorry, when we were going to the courtroom. I hope I won't have to do that again. But I am so curious about your thoughts as we sit here on a pivotal day for the nation.
Well, you know, first of all, live TV is live TV. So when the judge comes out, I go. But
appreciate that.
Listen, you know, watching the arguments, the moments that really jumped out at me because they just tugged at my insides were when Prosecutor Schleicher talked about the two men, about George Floyd and Derek Chauvin, and what was going on in their minds. And because I think that's something the jury will want to do. They'll want to understand why George Floyd acted the way he acted. And as Schleicher explained, he was feeling claustrophobic. He was being set upon. He didn't quite know what was going on. He was trying to cooperate. He was calling Chauvin Mr. Officer. And then why did Chauvin do it? Basically, he said because Chauvin could. Because he wanted to show everybody he was the boss. And I think now Eric Nelson is beginning.
Places on your personal and professional lives, especially in a case of this magnitude and duration. And so on behalf of Mr. Chauvin,
all right, we're going to listen in now as the defense attorney begins his closing argument.
To this jury. I'm going to apologize if I get a little long-winded, because I get one bite at the apple here. The state has an opportunity to rebut my statement after this. There's so very much we need to cover. There's so very much we need to talk about, and it is all important. Before I begin my review of the evidence in this case, I would like to address two very crucial points of law, and they were touched on by the state. The presumption of innocence and what proof beyond a reasonable doubt means. The presumption of innocence, the defendant is presumed innocent. That's the starting point. He's presumed innocent of these charges. And this presumption remains with him throughout the course of the trial, the presentation of the evidence, throughout the course of your deliberations, until and unless the state has proved its case beyond a reasonable doubt. The defendant does not have to prove his innocence. We talked about this in jury selection. We talked about the starting point. The defendant doesn't have to try to catch up. He starts at the presumption of innocence. Proof beyond a reasonable doubt. Here's the definition that the judge just read you. Proof beyond a reasonable doubt is such proof as ordinary prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt that is based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. The law recognizes three standards of proof. The preponderance of the evidence is the first and lowest standard. Clear and convincing evidence is the next standard. And the third standard is proof beyond a reasonable doubt. What these three standards mean is right? The scales of justice equally balanced. An example. That is the burden of proof that the state has. They have to just ever so slightly convince the finder of fact that supports their action. The next standard is clear and convincing evidence. I mean, that's pretty self-explanatory, right? It is clear evidence, and it convinces you, the finder, that the action is correct. This is the standard of proof that is used if the state wants to take away your children. Clear and convincing evidence. It tips the scales more in the favor of one party over the other. The highest standard in this country is proof beyond a reasonable doubt. Proof beyond a reasonable doubt. Essentially, what the state has to convince you is that the evidence in this case completely eliminates any reasonable doubt, or in other words, leaving only unreasonable doubt. Capricious, fanciful. Capricious doubt, capricious means unpredictable. Fanciful, space aliens flew in, inhabited the body of Derek Chauvin, and caused this death. That's fanciful. Beyond the reasonable doubt. It is the highest standard in the law. Doesn't mean beyond all possibility of doubt, because I suppose space aliens may have been inhabiting his body, but that's obviously fanciful and capricious. So these two standards, the presumption of innocence and proof beyond a reasonable doubt, work in concert with each other. You start with the proposition that Mr. Chauvin is innocent of these charges. The state has to advance substantial evidence to convince you that the only doubts that are remaining are unreasonable doubts. As you analyze the evidence in this case, you would simply have to find that any defense that has been advanced is unreasonable. That's what this standard is all about. I want to take this opportunity also to talk to you about the importance of reading the entire instruction. Because I've seen, and lawyers, and I'm going to do it too, right? We pick and choose those things that help us make our case and help us argue our case. That's our job as lawyers, is to point out words and phrases within the instructions that make the difference in the case, and to take that evidence and present it to you in such a way that it supports our proposition. That's what we do. That's why you are instructed that if your memories of the evidence is different, that if your The judge's law is what applies. But take the time to carefully read the entire instructions. Throughout the course of this trial, you've seen us do this, right? Little snippets. A second here, a second there, a screenshot here, a screenshot there. You need to review the entirety of the evidence in this case during the course of your deliberations as well. And I can tell you that some of the videos that we've seen, they're much longer than what was presented in court. There's additional information, and you're going to see some of that as we go through this case today. So take the time and conduct an honest assessment of the facts of this case, compare it to the law as the judge instructs you, and the entirety of the law. That's why the instructions tell you, consider the instructions as a whole. I've told you that lawyers like to present evidence that favors them, right? But we have to be intellectually honest about the evidence. We have to present it in an honest and intellectually cohesive and coherent manner. And I have to address something that I think is important. And I think it is a prime example of what I am asking you and what is your obligation to do to look at the evidence in light of all of the other pieces of evidence, right? So you heard during the testimony of Dr. Fowler that one of the things that he considered is the possibility that carbon monoxide was present and could have contributed to an environment that created an oxygen deprivation. You heard that testimony. In rebuttal to that testimony, the state brought Dr. Chauvin back in, and he told you, we can completely disregard that. We know as a fact, we know conclusively that Mr. Floyd did not have carbon monoxide because his oxygen was saturated to 98%. And you just heard the state say, just like I am right here, right? So it stands to reason. I could get up in front of you and I could argue to you, we know this wasn't asphyxiation because George Floyd had a 98% oxygen level. How could he have been asphyxiated at the hospital with a 98% oxygen level? But that's not intellectually honest. It doesn't stack up against the rest of the evidence because of what we know, right? We heard the testimony of Seth Bravender and Derek Smith, the paramedics. We heard the testimony of Dr. Langenfeld. They came in and they said they began resuscitative efforts. They introduced oxygen, an oxygen supply. They're manually breathing for him. They're re-oxygenating his blood. So when you look at that piece of evidence, when you look at you have to all of the other evidence, because you can't come in and say George Floyd, on one hand, George Floyd died of asphyxiation, but he has a 98% oxygen level, right? His blood is oxygenated. Then stands to reason the opposite is true as well. You can't come in and say, I can conclusively prove that Mr. Floyd didn't have carbon monoxide in his blood because he had this high oxygen saturation. You test one statement against the evidence of other people and you compare it. That is what you as jurors are obligated to do and what I am asking you to do. Compare the evidence against itself. Test it. Challenge it. Compare it to the law. Read the instructions in their entirety. Start from the point of the presumption of innocence and see how far the state can get. I submit to you that the state has failed to meet its burden of proof beyond a reasonable doubt. Mr. Chauvin has been charged, as the state indicated, with these 3 charges, and the judge has instructed you. Count 1 is second-degree murder while committing a felony. It's also called the felony murder rule in Minnesota. Kind of the textbook example is I run into a liquor store, I pull a gun, I'm intending to rob the liquor store. My gun goes off, I shoot and kill the teller. I didn't intend to go in and murder that person, but the death of that teller occurred while I was committing a felony. That's the felony murder rule. He's been charged with murder in the 3rd degree for performing an intentional act that is eminently dangerous. Right? You've seen the instructions, you've heard them. And manslaughter in the 2nd degree. Again, the law has all of the words, it defines the words you need, and the instructions should be considered in their entirety. Whenever I meet with a client, I try to explain what the elements are, and this is the analogy that I use. I say that a criminal case is kind of like baking chocolate chip cookies. You have to have the necessary ingredients. You've got to have flour and sugar and butter and chocolate chips and whatever else goes into those chocolate chip cookies. If you have all of the ingredients, you can make chocolate chip cookies. But if you're missing any one single ingredient, you can't make chocolate chip cookies. It's a simple kind of analogy. But the criminal law works the same way. We say, we call the ingredients the elements. The state has the burden of proving each and every element beyond a reasonable doubt. Not just some global proposition that they've proved their case beyond a reasonable doubt. They have to prove each of these elements beyond a reasonable doubt. And if you determine that they have done so, you convict. But if they are missing any one single element, it is a not guilty verdict. And you saw the spreadsheet that the state put up, right? The elements are a little different in each of these cases. And some of these elements will take less of your consideration. You will have to look at the evidence, and you will have to, for example, determine is Cup Foods in the city of Minneapolis, is Minneapolis in the county of Hennepin, is Hennepin County in the state of Minnesota? Did this happen on May 25th, 2020? Right? It's going to take less of your consideration, but nevertheless, you have to do that. You have to go through that process. Two of the elements that I want to focus on during the course of my discussion here today, two of these elements are common throughout, or two of these issues are common and apply to all 3 counts. And so I want to focus my remarks today on those 2 issues. The first, were Mr. Chauvin's actions an authorized use of force by a peace officer, right? Because in the instructions, it specifically tells you no crime is committed if it was an authorized use of force, period, end of discussion. The second is an element that is and does appear in all 3 counts. That is the cause of death. What caused Mr. Floyd's death? And we're going to talk about that second. So, let's start with the concept of reasonable force. As the instructions read in their entirety, no crime is committed if a police officer's actions were justified by the police officer's use of reasonable force in the line of duty in effecting a lawful arrest or preventing an escape from custody. The kind and degree of force a police officer may lawfully use in executing his duties is limited by what a reasonable police officer in the same situation would believe to be necessary. Any use of force beyond that is not reasonable, To determine if the actions of the police officer were reasonable, you must look at those facts which a reasonable officer in the same situation would have known at the precise moment the officer acted with force. You must decide whether the officer's actions were objectively reasonable in light of the totality of the facts and circumstances confronting the officer and without regard to the officer's own subjective state of mind, intention, or motivations. The defendant is not guilty of a crime if he used force as authorized by law, and to prove guilt, the state must further prove beyond a reasonable doubt that the defendant's use of force was not authorized by law. So, if you remember from my opening statements and how I talked about reason and common sense, right? The reasonable police officer standard. I want to just briefly add one thing here, is the standard is not what should the officer have done in these circumstances. It's not what could the officer have done differently in these circumstances. The standard is what were the facts that were known to this officer at the precise moment he used force, and considering all of the totality of circumstances and facts known to the officer, what would a reasonable police officer have done? You have heard from numerous experts, police use of force experts, the training department from the Minneapolis Police Department. You've heard from police officers, street police officers, Sergeant Edwards, Sergeant Pluger, right? So you've heard from these people, and they have given you their opinions at various stages as to the reasonableness of the use of force. But one of the things that one of the things that all of these police officers effectively agreed to is that when you look at the question of what would a reasonable police officer do, knowing the facts of the case, there are things that a police officer is entitled to take into consideration above and beyond the facts, right? Their training, the training that they receive, their experience as a police officer, the department's policies on the use of force. And all of these things kind of lead into the question of, most critically, what are the facts that were known to the police officer, the reasonable police officer, at the precise moment the force was used? So you can start at a very high level, right? What were the reasonable police officer's knowledge of the area be? Is this a high crime location? Is it a low crime area? Those are things, those are facts that a police officer would know. What are the specifics of the location of arrest, right? Am I going into a densely populated urban environment, or am I in a kind of a secluded backyard, right? Officer is calculating these pieces of information and assessing the risk, assessing the threats. Officers are entitled to kind of take into consideration things that you and I don't think about. Their tactical advantages, their tactical disadvantages. They can take into consideration the scene security, keeping the scene secure, and security of the scene, right? Those are two different concepts. So kind of, again, focusing back into what facts were known at the precise moment force is used, you can then take into consideration kind of this mid-range level of information. A reasonable officer wants to keep his fellow officers safe. A reasonable police officer takes into consideration the safety of civilians. The reasonable police officer takes into account the safety of the person that they are arresting. They take into account what resources do I have based upon How close am I to a hospital? What's the expected time if I call EMS? Because a reasonable police officer at times, they got to put the person in their squad car sometimes and take them because they're farther away. Calling for help, bringing help in would take longer than it would simply to take the person directly. And then you look at the direct knowledge that a reasonable police officer would have at the precise moment force was used. That includes information that they gather from dispatch, their direct observations of the scene, the subjects, and the current surroundings. They have to take into consideration whether the suspect was under the influence of a controlled substance. They can take into consideration, because again, this is a dynamic and ever-changing, just like life. Things change. It's a dynamic situation. It's fluid. They take into account their experience with the subject at the beginning, the middle, the end. A reasonable police officer tries to predict or is at least cognizant and concerned about future behavior based upon past behavior. But the unpredictability of humans factors into the reasonable police officer's analysis too. Because sometimes reasonable police officers take someone into custody with no problem, and suddenly they become a problem. It can change in an instant. A reasonable police officer will take into consideration his immediate surroundings. Are there bystanders? Are there civilians? A reasonable police officer will take into consideration who he is at the scene with. Are these veteran officers? Are they rookie officers? What do I know about my partners and my partner's abilities? So throughout the course of this trial, the state has focused your attention on 9 minutes and 29 seconds. The proper analysis is to take those 9 minutes and 29 seconds and put it into the context of the totality of the circumstances that a reasonable police officer would know. And the proper analysis starts with what did the officers, or what would a reasonable officer know at the time of dispatch? Well, these are records that are kept. They've been introduced. You can look at them. This is Exhibit 151. This is the computer-aided dispatch report. You heard the testimony of Jenna Scurry, the 911 dispatcher. This is information that they are passing out to the officers. You will see that the initial information that a police officer has in his squad car looking at his computer or hearing over the radio was that on May 25th, 2020 at 20:02:13, so that's 8:02:13, a business, Cup Foods, who police officers have the obligation to respond to these calls, whether it be from a person or a business. But a citizen of the state of Minnesota, Minneapolis, runs a business and they called for assistance. And they told the officers, the reporting party, there is a male who provided a counterfeit bill to the business. He's 6 feet tall or higher. He's sitting on top of a blue Mercedes ML320 SUV. The license plates also appears this subject is under the influence. So the analysis of what a reasonable police officer would know in this circumstance is that a business is requesting its help. The suspect is still there. He's large, and he's possibly under the influence of alcohol or something else. So the analysis begins at 8:02 and 13 seconds. You may recall the testimony of Jenna Scurry as well, and it's not reflected in this exhibit pretty well, but in the evidence, exhibit number 10, you can hear the audio recording of the dispatch. Jenna Scurry to the officers. Jenna Scurry informed you that initially Officer Chauvin was assigned to this call on a Code 3 Priority 1 basis. It's Code 3, get their lights and sirens, get there fast, right? It's Priority 1 because the suspect is still on scene. So per the Minneapolis Police Department policy, get there fast, the person is on scene, right? That's what she testified. And then very quickly after that, that occurred at 8:04 and 28 seconds. Then what you see is what she told you was that the sector car 320, that's the car that patrols this part of the city, said, hey, we can take this call, and Officer Chauvin and Officer Tao were canceled from the call, right? So they were canceled from the call, and sector car 320, Officers King and Lane took it, and that occurred at 8:05 and 11 seconds. When Officer King and Lane took it over, you can hear, again, you can go back and you can listen to that audio of that dispatch, and you can hear them talking to each other. Officers King and Lane arrive at the Cup Foods at 8:08 and 20 seconds. So now we see police officers are responding. They're on scene at 8:08. Both Jenna Scurry and Peter Chang described that during the course of the interaction between the initial interaction between Officers King and Lane and Mr. Floyd, through dispatch they heard what sounded like the sounds of a struggle. Jenna Scurry described she's trained to listen. She heard these sounds of a struggle, and she aired out on her own, other officers need to respond, Code 3, to assist Officers King and Lane, right? So a reasonable police officer, he's going emergent to a scene, he gets canceled from the scene, he's now being told that other officers need assistance, and step it up, get there fast. So you can see again, based on the records, that at 8:10:08, 20:10:08, backed up 320 with 330, right? So now 330 is Officer Chauvin and Tao. They're backing up Officer King and Lane. And you can see Peter Chang respond at 8:10 and 21 seconds. You hear 320 taking one out. So that means they're removing someone from the vehicle at 8:11:02. The scene is ultimately C4, Code 4, all clear at 20:12:21. So literally this demonstrates to you a couple of things. How quickly a situation can change from second to second, minute to minute. They went from get there fast, back off. Get there faster because someone needs help. It's clear. The situation is dynamic and it's fluid. They're provided with information that an officer needs assistance. They testified about the sound of a struggle, right? And if you recall, Sergeant Steiger specifically this information to a police officer, and it goes into and factors into the use of force. Ultimately, Officer Chauvin and Officer Tao arrive at Cup Foods. Just pause this for 1 second here. Sorry. when we look at Officer, I just have to give you a little piece of information. When we look at Officer Chang's video, Officer Chang arrives first. You see the time is 1:16:33 Z, Zulu. That's Greenwich Mean Time. Subtract 5 from 1 a.m., get you back to 8. So, Officer Chauvin and Officer Lane pull up. 8:16. Go over there.
Okay, just stay put, all right? I don't want anybody near his car.
Information gathering in terms of this assessment and reassessment of, again, the decision-making process of a police officer, right? Don't come over here where I am, Officer Chang says. Go over there. They need your help. Because what at that point, at that precise moment, they don't know what's happening over at the squad car. They don't know that Officers King and Lane struggled with Mr. Floyd, getting him out of the car, that they sat him down, that they stood him up, that they walked over. They haven't seen any of this information, and there's no evidence to suggest that they had. So that doesn't factor into the information. It's, again, a reasonable police officer. What do they know? And they don't know that. But they're starting to get some indication, hey, go over there, right? Go over there. You can see right at about 8:17, and I apologize for the quality of the picture, Officer Chauvin is arriving and walking up to the squad car. So what would a reasonable police officer see in this instance? What a reasonable police officer would see could be defined, because again, a reasonable police officer has to be aware of his department policies: active aggression or active resistance. Let's call it active resistance. A response to police efforts to bring a person into custody or control for detainment or arrest. A subject engages in active resistance when engaging in physical actions or verbal behavior reflecting an intention to make it more difficult for officers to achieve actual physical control. So as Derek Chauvin walks up to this scene, he has all of the information from dispatch. He has all of the information from Officer Chang sending him over. He knows his department policy on the difference between active aggression, active resistance, passive resistance, based on policy, training, etc. This is an officer's consideration of, again, the use of force. All of these things factor into it. So what does he see? He sees Officers King and Officers Lane struggling with Mr. Floyd, attempting to put him into the car. He hears the words that Mr. Floyd is saying at that point. I'm claustrophobic. I'm a good guy. I'm a good man. I'm claustrophobic. I just had COVID, right? He's hearing this information. He's observing with his eyes. A reasonable police officer is observing this with his eyes and his ears and assessing what he sees pursuant to policy. And what he sees, at a minimum, is active resistance. Mr. Floyd's not just simply getting in the backseat of the car. So let's watch. What does Officer Chauvin see when he walks up? This is from his body camera from 8:17 and 21 seconds to 8:18 and 15 seconds. Just shy of a minute.
You can't win. I'm not trying to win. Go on, get in the car. I get on the ground, anything. Go on, get in the car. He know it. He know it too, Mr. Officer. Y'all hear me? Don't do me like that, man. Please. Okay, can I talk to you, please?
That's what you get in this car. We can talk.
I am claustrophobic. I'm claustrophobic, man.
Working with me.
God, I'm claustrophobic right there, man. Can I get in the car? Get in the front? Please.
No, you're not going to
I'm claustrophobic, Mr. Officer.
Get in the car.
Okay. I'm not a bad guy, man.
Get in the car.
I'm not a bad guy. You ain't gonna win. Please. Please, man. Please.
Hold on a minute.
Hold on.
You take the seat. Hold on a minute.
I can't choke. I can't breathe. Please. Please. My wrist, man. My wrist, man. Please. I can't take that, man.
By 8:18 and 15 seconds, Officer Chauvin has not laid a finger on Mr. Floyd, but he's observing, and a reasonable police officer is doing this. He walks onto a scene, he sees active resistance occurring, potentially active aggression occurring. He has two other officers. He has not intervened. But again, based on the policies and the training that you have seen, what were his options available to him at that time? If a person is actively resisting in the center, distraction techniques, controlled takedowns, conscious neck restraints. Can you clear that in? Right. These are options available to Mr. Chauvin at this point. He has, per his training, these techniques at his disposal. A reasonable police officer would be making these observations. He would observe the white foam around Mr. Floyd's mouth. He would consider the possibility that this person was under the influence of something. Basically, using the information from dispatch, making these observations, how is he analyzing this? How would a reasonable officer analyze this, and what would be known to a reasonable officer? A reasonable officer would look at the size of the person and assess that person's size in relation to his own size, because it's a part of the risk-threat analysis, right, that we've heard about so much. A reasonable officer would know that these are two rookies putting this man in the car. In fact, as the evidence established, Mr. Chauvin trained one of the officers. So a reasonable officer may step back at this point to see if these two guys can get this under control. A reasonable officer will hear the words that the suspect is saying. I'm a good guy, I'm a good guy, I'm a good guy, I'm claustrophobic, and he's going to compare those words to the actions of the individual, right? Because this is part of the analysis. Because I can say, I'm going to cooperate with you, I'm going to do whatever I want, but if my behavior is inconsistent with what I am saying, a reasonable officer takes that into consideration. In fact, a reasonable officer who's aware of his department policies knows the de-escalation policy that is in place. And part of what a reasonable officer has to do is to consider whether a subject's lack of compliance is a deliberate attempt to resist or an inability to comply based on these factors: medical conditions, mental impairment, developmental disability, physical language, language barrier, influence of drugs or alcohol, or behavioral crisis. So an officer, a reasonable officer, has to take the information and assess, is this suspect purposefully or intentionally, deliberately trying to thwart our efforts to take him into custody, or are they experiencing one of these other types of factors? But such consideration, when time and circumstances reasonably permit, shall then be balanced against the incident facts when deciding which tactical options are the most appropriate to resolve the situation safely. So again, reasonable officer, in any of these circumstances, is going to take all of this information in, all of these policies, all of these training ins, and a reasonable officer at that point would conclude that the amount of force that was being used by Officers King and Lane was insufficient. It was not enough use of force to overpower Mr. Floyd's resistance to getting into the car. He's seen it, he's heard it, he's familiar with the policies. And so, at precisely 8:18 and 15 seconds, Officer King, Officer Lane, and Officer Chauvin struggled, fought, whatever adjective you want to use. They struggled with Mr. Floyd from 8:18 till 8:19 and 12 seconds. About a minute, a little over a minute. It doesn't really seem that it's that long of a time, but again, the amount of physical exertion. Remember how Sergeant Jody Steiger described this. When the apparent attempts to get him into custody were futile. I wrote his quote down. The futility of their efforts became apparent. They weren't able to get him into the car. 3 Minneapolis police officers were not able to get Mr. Floyd into the car. They themselves are experiencing that surge of adrenaline. A reasonable police officer will be experiencing that surge of adrenaline. And again, balancing all of the evidence against each other, right? Let's look at 3 different angles of this struggle. This is Officer King's body camera.
I'm going down. I'm going down. I'm going down.
Get with the squad.
I'm going down. I'm going down. I'm not going to leave you. Bro, you want down a heart attack, man. I know I can't breathe. Get in the car. I can't go get man. I can't breathe.
Take a seat.
Please, man. Please listen to me.
Is he going to jail?
Listen to me.
He's under arrest right now for forgery.
I'll tell you.
Don't figure out what's going on.
Forgery for what?
Take him out.
For what? Please, man. I can't fucking breathe.
Hey, come on out.
Look at you. Thank you. Thank you.
Get him on the ground. Yeah, on the ground. On the ground.
He's under arrest for forgery. Forgery for what? This is the video of the same time period from Officer Lane.
I'm on the ground. I'm on the ground. I'm on the ground.
Get in the squad.
I'm on the ground. I'm on the ground. I'm going down. I'm going down. I'm going down.
Get in the squad.
I'm going down. I'm going down. I'm not going to breathe. Bro, you got a heart attack shit, man. Get in the car. I know I can't breathe. I can't breathe.
Talk to the squad. Get some oxygen back.
I can't go me, man. I can't breathe. I can't breathe. Please, man. Please listen to me.
Is he going to jail?
Listen to me.
He's under arrest right now for forgery.
I tell you.
Don't figure out what's going on.
Forgery for what?
Just take him out and just.
For what?
MRE.
Please, man. I can't fucking breathe.
Yeah, just get up
On the ground.
I appreciate that.
Officer Tao.
I'm on the ground. I'm on the ground. I'm on the ground. I'm going down. I'm going down. I'm going down. I'm not going to run, man. Right. I know I can't breathe. I can't breathe.
You're talking to me. Oxygen back. Not breathe.
I just had COVID, man. I can't breathe. I can't.
It's gonna
He's under arrest right now for forgery. What's going on?
what? Let's take him out in this thing.
What? Please, man.
Yeah, just
on the ground.
I appreciate that.
A reasonable police officer understands the intensity of the struggle. You can see at points when Mr. Floyd's legs kick back, it actually almost knocks Officer Lane over. Right? It knocks off the body-worn camera and the badge of Officer Chauvin in this struggle. A reasonable police officer would understand this situation, that Mr. Floyd was able to overcome the efforts of 3 police officers while handcuffed with his legs and his body strength. A reasonable police officer standard can be seen in another way, from the milestone camera. And this is what caught the attention of the 911 dispatcher, Jenna Scurry. She said she observed the struggle and the vehicle rocking back and forth, back and forth. Watch the vehicle. Reasonable police officers will consider their training, right? And before we talk about the training again, there's something that I think is really important to understand. 2 things, actually, at this moment. Not a single use of force expert that testified, not a single police officer who testified said that anything up until this point was unlawful or unreasonable. It was reasonable for these officers to put them into Mr. Floyd into the squad car. It was reasonable. The efforts that they took to overcome his resistance were reasonable. Every single expert agrees that to this point, nothing is contrary to policy, training, defensive tactics, crisis intervention, all reasonable. It's at the point that Mr. Floyd is brought to the ground that there becomes dispute about the reasonableness of the use of force and what a reasonable officer would know. It was Seth Stoughton, the law professor, who said at the point Mr. Floyd came out of the car, putting him on the ground was unreasonable. So, Was it reasonable for Officer Chauvin or a reasonable police officer to put Mr. Floyd on the ground in that instant? So a reasonable police officer is going to rely on his training and information, his evidence, what he knows, all of the information he's built up to this point. You heard Lieutenant Mercel testify about how about 15 years ago the Minneapolis Police Department went to ground defense tactics, getting people on the ground to control them, control the head, control the body. Different types of moves that the police use to create and eliminate space. Escape versus control. Those are two different things. These are the tactics that have been employed by the Minneapolis Police Department for 15 years. Why? Because it's safer for the officers and it's safer for the suspects. It keeps people contained, controlled, and confined until they no longer are resisting. A reasonable police officer would also consider his department's policies, including the use of non-deadly force policy. Force that does not have the reasonable likelihood of causing or creating a substantial risk of death or great bodily harm. This includes, but is not limited to, physically subduing, controlling, capturing, restraining, or physically managing a person. This is the policy, 5-302 of the Minneapolis Police Department, that non-deadly force can be used to physically manage a person. And again, every single person has agreed that the use of force up to this point is reasonable, lawful, and meets the reasonable officer standard. And so we get into the 9 minutes and 29 seconds at this point. And the state has really focused on the 9 minutes and 29 seconds. 9 minutes, 29 seconds. 9 minutes, 29 seconds. It's not the proper analysis, because the 9 minutes and 29 seconds ignores the previous 16 minutes and 59 seconds. It completely disregards it. It says, in that moment, at that point, nothing else that happened before should be taken into consideration by a reasonable police officer. It tries to reframe the issue of what a reasonable police officer would do. A reasonable police officer would, in fact, take into consideration the previous 16 minutes and 59 seconds. Their experience with the subject, the struggle that they had, the comparison of the words to actions, it all comes into play. Why? Because human behavior is unpredictable. Human behavior is unpredictable, and nobody knows it better than a police officer. Someone can be compliant 1 second and fighting the next. Someone can be fighting and then compliant. Nobody knows it better. But reasonable police officers continue to assess and reevaluate. This is the critical decision-making policy, right, or model. You gather information, you assess the threat versus the risk. Do we have an authority to act? What are our goals and actions? Review and assess. Start over. Because this is not a singular cycle. This is a cycle that humans, as humans, we literally make millions of decisions in a day, right? Do I go this way? Do I go that way? Do I go up? Do I go down? I mean, we are constantly doing this. This is just human behavior. But in the policing context, you have to gather the information, assess the risk, assess the threat. Do I have authority to act? What are my goals and actions? Review and assess. And it's constantly rotating. At the precise moment that Mr. Floyd was laid on the ground, a reasonable police officer would know about those previous 17 minutes. A reasonable police officer would know about the struggle. reasonable police officer would consider the suspect's reactions to the previous use of force. A reasonable police officer would continue this process of reassessment. And a reasonable police officer would consider whether to use an additional force to overcome the suspect's level of resistance, right? So 9 minutes and 29 seconds.
I appreciate that. I do.
You got your Jesus.
Thank you.
That movement. Mama.
Continuing to assess the risk and the threat. The first 20 seconds, continued resistance is what a reasonable police officer would interpret that to be. Jesus Christ, the kicking. A reasonable police officer would consider, should we elevate the use of force as we meet this threat? And that's precisely what these officers did. They discussed using the MRT, the hobble.
Oh, please, man. There you go. You're doing a lot of Mama, I love you.
We're calling for
I can't do nothing.
Yeah, EMS is on their way.
My face is gone.
Well, do you want to hobble at this point then?
I can't breathe, man. Please. Please let me stand. No. Please, man, I can't breathe.
They're discussing, should we use the hobble? Should we elevate our use of force? A reasonable officer would continue to evaluate whether the suspect is under the influence. Precisely what these officers did in this 9 minutes and 29 seconds.
The clerk's still sitting on the car there.
Look at my face, man.
I believe so. We're trying to fight him. Get out of the car.
I ain't doing this real. Please. Please.
Two other people with him.
Please, I can't breathe. Please, man. Please. Mama.
On a weak pipe on him, there might be something, so that might be like
I can't. I'm big.
Is that the
All right.
shaking of the eyes, right? Is PCP?
My knee. My neck.
Are their eyes like shaking?
I'm through. I'm through.
So reasonable police officers discuss the scene. The first clip, they're talking about the two other people that are over at the car, right? What's going on here? What are we dealing with? Is this person under the influence of a controlled substance? These are the actions of a reasonable police officer. A reasonable police officer would rely on his training and experience. Call EMS. Possibility that a suspect who was struggling with us will begin to struggle again. You've heard this testimony from multiple police officers. The risk that the suspect would present to himself if he's not continued to be controlled, and the risk that the suspect presents to other officers or citizens if not continued to be controlled, if he's not continued to be controlled, right? These are things that all of the police officers have testified about. These are what a reasonable police officer should do. A reasonable police officer in this situation would call EMS. 2020, 11, 8/20/11. Within a minute of the struggle, EMS code 2 for a mouth injury, right? Because they are not observing life-threatening, a reasonable officer is not observing life-threatening injuries at this point. They just fought with the man for a minute. He continued to kick at them when they got him on the ground. They see he's got a mouth injury. We need EMS. So a reasonable police officer would evaluate the injuries of the suspect, compare words and actions, and respond by calling EMS. Non-emergency. But again, reasonable police officers evaluate, reevaluate. 2021, 8:21, 1 minute and 24 seconds later. We need EMS here faster. Code 3. 3:30. We need them here faster. A reasonable police officer would take into consideration the anticipated time of a emergent response. You heard from Genevieve Hansen, there's a firehouse a few blocks away, and she would have expected EMS to be there within minutes. 3 minutes is what she said. A reasonable police officer, based on his training and experience, is going to have and take that into consideration. I put this person in a prone position on the ground. I'm holding them for my safety and their safety. I'm expecting someone to be here within 3 minutes to help this person. I have called for that help. A reasonable police officer will take into consideration, again, his training, his experience, right? Lieutenant Mercil talked about, and many people talked about, many of the officers talked about how it is not uncommon for suspects to feign or pretend to have a medical emergency to avoid being arrested. Unfortunately, that is the reality. Nobody likes to get arrested, and reasonable police officers know that. How many times does someone, oh, my heart hurts, or I'm having a medical emergency, insert whatever emergency, right? Simply because they don't want to go to jail. A reasonable police officer will take his training into experience. And you heard Lieutenant Mercil specifically say that when someone says that they can't breathe, but they are talking, if they're talking, it means they're breathing, right? If they're talking, it means they're breathing. And again, compare that to the testimony of Dr. Chauvin, who told you that same thing. That is true. If you are talking, you are breathing. It doesn't mean effectively. And Dr. Chauvin described how even medical doctors have problems sometimes assessing the legitimacy of a patient's needs relevant to their respiratory processes, because they're saying, I can't breathe, and some doctors confuse it for just anxiety or this or that. So if medical doctors make these mistakes, Dr. Chauvin told you it provides a false sense of security, right? Lieutenant Mercil told you that that is what is said among police officers. He's the trainer. So how many times do we hear an officer say, based on his training and experience, if you can breathe, you can talk. If you can talk, you can breathe. Excuse me. I counted 7.
Please, man. Please. I can't choke. I can't breathe. Please.
You're talking. Sit down.
Fine. My wrist. I know I can't breathe. I can't breathe.
You're talking to me. Oxygen. Not breathe.
I said.
Relax.
I can't breathe.
You're doing fine. You're talking fine.
I can't breathe. I can't breathe. Please. I can't breathe, officer.
You're talking. A lot of yelling.
They will give me, man.
Takes a heck of a lot of oxygen.
Come on, man.
Reasonable police officers, again, are trained and take into consideration a person's actions relevant to their words, their training, their experience. Takes a lot of oxygen to talk. Takes a lot of oxygen. You're breathing fine if you can talk.
I can't breathe. He's talking, so he's fine. Okay. We tried that for 10. He's talking, he's fine. Bro, he ain't. Okay. All right, we're done. You circled. Okay, we're done.
Reasonable police officers will take into consideration their training and experience on excited delirium, and they will analyze it within the context of this case.
I just worry about the excited delirium or whatever.
That's fine.
I worry about the excited or delirium or whatever. That's why we have EMS coming. It's not just leave them here. It's we have EMS coming, and this is why we have EMS coming. Reasonable police officers, throughout the course of a control technique, will continue to assess the level of resistance. And remember what Lieutenant Johnny Mercil said. Simply because a person isn't kicking at you or punching at you or biting at you, it does not mean that you can't control them physically with your body weight. This is at 8:24. This is the point where Dr. Chauvin testified that Mr. Floyd had an anoxic seizure, right? But it's not, we're not analyzing the use of force from the perspective of a doctor with 46 years of medical experience who had 150 hours of time to watch an event from multiple perspectives over and over and over and over again. It's a reasonable police officer standard. How would a reasonable police officer interpret this? Does a reasonable police officer even know what an anoxic seizure is? A reasonable police officer will interpret this as at least some form of minimal resistance. Reasonable police officers, again, are continuing to monitor. They're expecting EMS to arrive.
Bro, but you're already talking to the ground. You're being a bum right now. You get him off the ground, bro. You can get him off the ground, you get him a bum. Body language is crazy.
Non-deadly force is included. It includes, but it is not limited to, physically subduing, controlling, capturing, restraining, or physically managing a person. These are the policies of the Minneapolis Police Department. Reasonable police officers, again, continue to monitor. See if he's breathing.
I think he's passing on.
Breathing right now, bro. You think that's cool? You think that's cool, right?
Just all that the post is available if you could start for an assault at next door to 2313 Washington Street.
Yeah, I mean, I need my deal and scratch, but I'll survive.
I think he's passing out, but he's breathing, right? This anoxic seizure occurs. Reasonable police officers are building and basing their decisions based on all of these factors coming in at multiple times, including the bystanders. Right? Call them a crowd, call them onlookers, call them bystanders. It doesn't matter what term you use for the people that gather to watch what police do. Reasonable police officers are cognizant of and aware of their surroundings. And before I really kind of start talking about the crowd in some limited detail, I have thought a lot during the course of this trial about the difference between perspective and perception. Perspective and perception are two distinct concepts. Perspective is the angle at which you see something. It's your perspective. Perception is how you interpret what it is that you see. I've thought about this a lot during the course of this trial because this situation here in the courtroom is incredibly unique, right? It's not the normal setup for a jury trial. So my perspective through the course of this trial, sitting in this chair, is that I cannot see 4 of the jurors. Very limited opportunity to observe the jurors. They probably can't see me either. Several of the jurors I have a very good view of. 4 of the jurors I don't, and obstructed views of others. My perspective sitting in this chair when witnesses, there's a camera blocking the head. So in order for me to see the witness, I have to roll all the way over to the other side. Then I have to look through the plexiglass that has these large reflecting lights. Right? Things block your perspective. Things can affect your perspective. But your perception is how you interpret what it is you see and what it is you experience. And that is our life, right? This is our experiences. These are the things that make us who we are. 3 people in this trial went to the same high school. Me, Darnella Frazier, and Chief Arredondo. We all went to the same high school, obviously at different times. My experience, Chief Arredondo's experience, Darnella Frazier, same perspective, sat in the same classrooms, saw the same chalkboards or whiteboards, the same perspective, but our perception of our experiences there is going to be much different. Ultimately, at the end of the case, when we're done with these arguments, the court will instruct you on how to deal with these biases and the perception issues. The court's final instructions will guide you to try to recognize your biases, recognize them, what we bring to the table, and analyze the evidence from the perspective of the evidence itself. So let's look at this incident on May 25th from the perspectives and perceptions of simply just 4 of the bystanders. Right? Charles McMillan, 61 years old, 3rd grade in education, grew up in the South. He described himself as a curious guy. He likes to know what's going on in his neighborhood, so he stops and he checks things out, right? His perspective, he's the first one who's dealing with these guys. He has more information because he sees the entirety of the situation. But his perception of the event is affected by his life's experiences. At the end of the night, ultimately what he said to Officer Chauvin was, "I hope you get home safely," because that's what he says to police officers every night.
Can you advise the fire department if they're still with you, they need to go to 36th Park to assist with the
But I feel respect you. That's one person's opinion. But no, I gotta get him. We gotta control this guy because he's a sizable guy. Yeah, and I gotta get in the car. Looks like he's coming on something. But I'm just saying, but no, I got nothing bad to say about you because you respect me, I'm gonna keep respecting you. You have a good night. You go home safe with your family. They'll keep you the same.
Darnella Frazier. She's a 17-year-old high school student who, upon seeing the restraint of George Floyd, her response was to pull out the cell phone and start recording, and then subsequently upload it to Facebook, right? her perception of the event and her perspective of the event. She's looking, she didn't even know that Officers Lane and King were there because her perspective was blocked by the squad car. But her perception, her response to the situation was to record it, and that's perfectly fine. But she began her recording at 8:20 and 51 seconds. Donald Williams, he's a 33-year-old professional mixed martial artist who arrived at 8:22 and 39. He had spent the day fishing with his son, stopping for a drink when he became aware of the incident. He described his view of this based upon his perception as a mixed martial artist, right? He has a set of experiences that caused him to react in a different way. What he perceived was happening was that Mr. Floyd was being choked with a blood choke. I think we're past this at this point. The paramedic reached in, touched the carotid artery. To have a person rendered unconscious through a choke requires the blockage of both carotid arteries. This was not a neck restraint. This was not a chokehold. He was upset. And that, again, is okay because his perception affected what he was seeing. Genevieve Hansen, right? 27-year-old female firefighter for the city of Minneapolis. She testified that when she walked into the scene, she described the crowd as upset. She said, I walked into an upset crowd. She said that the other voices distracted me from getting the officer's attention. And she testified, again, based on her perspective, that Officer Chauvin appeared to have his hand in his pocket. She observed what she believed to be blood on the from Mr. Floyd's face being pressed into the pavement. She observed fluid coming from Mr. Floyd's body that she presumed to be urine. She testified that nobody ever told her that EMS or an ambulance was on the way. She asked about, when I asked her about the response time she would have expected, 3 minutes. When I told her that paramedics had been called about 5 minutes prior to her arriving on scene, no way, because her perception is 3 minutes. But when you look at the things that Ms. Hansen saw, whether it be from her perspective or her perception, there can always be more to the story. The blood coming from Mr. Floyd's nose was why they called EMS in the first place. You've seen the pictures. He injured his nose during the struggle, or his face during the struggle in the squad car. The fluid that she described as potentially being urine, we know that that's fluid coming from the undercarriage of the squad car.
I cannot breathe.
Officer Chauvin specifically told her an ambulance was coming when she first came on scene.
Don't come over here. Don't come over here.
Off of the sidewalk.
Yeah, we need you to keep some distance. Yeah, we got an ambulance coming.
Yep, we got an ambulance coming. The computer-aided dispatch reports clearly show what time EMS was called. So Genevieve Hansen has a perspective and a perception. And what she observed was not consistent with the actual evidence. But remember, we don't look at this incident from the perspective of a bystander. We do not look at this incident from the perspective of the people who were upset by it. We look at it from the perspective of a reasonable police officer. A reasonable police officer, when confronted with these bystanders, would know everything that had occurred up to that point. 20 minutes, 25 minutes, 30 minutes. They know all of that information. The bystanders do not. A reasonable police officer would understand that his actions were actually being recorded. Take the bystanders out of it. Officers wear cameras for a very specific reason, to record their actions, so they know they're being recorded. Officers are aware of the placement of city cameras. You're in a high retail, you've got gas stations, restaurants, convenience store, high surveillance. Right? Reasonable police officers know this. They would know if citizens take out their cell phones and start filming. This is the point at 8:20 and 49 seconds when Miss Frazier starts recording. Reasonable police officers are aware when they're using force that sometimes what they are doing does not look good to the general public. A reasonable police officer will hear the frustration growing. Right? A reasonable police officer will hear the increase in the volume of the voices. A reasonable police officer will hear the name calling, right? Chump, whatever names are being called. They'll hear the cursing. They'll hear this, and they'll take that into their consideration. A reasonable police officer will rely on his recent training. Excuse me. A reasonable police officer will hear what I'll come back to the training. A reasonable police officer will hear what the crowd is saying. He will compare his actions to what they are saying, and he will determine, I know I'm being recorded, right? I know I'm being recorded. They're saying that I'm doing something that's awful looking. Am I doing this?
Right. What I'm saying, you can put him in the car. You don't gotta sit there with your knee on his neck, bro. Bro, he ain't crying, bro. You circle it like in a jiu-jitsu move, bro. You trapping his breathing right there, bro. Like. He's talking. Bro, but you can get him off the ground. You've been a bum right now. You can get him off the ground, bro. You can get him off the ground. You've been a bum.
You can see Officer Chauvin's body language tells us a lot, right? That's what we just heard. Looking down, looking up, looking around, looking down, looking over, looking around. He's comparing a reasonable police officer. He's doing what a reasonable police officer would do. He's comparing his actions, his own actions, in response to what the crowd is saying. A reasonable police officer, again, training. 2020, March of 2020. Very dynamic, rapidly. That this is in dealing and things of that nature. These are the tactics, but you never underestimate a crowd's potential, because a reasonable police officer has to be aware and alert to his surroundings. A reasonable police officer will consider his department's policies on crisis. And what is defined as a crisis? Crisis. An event or situation where an individual's safety and health are threatened by behavioral challenges to include mental illness, developmental disabilities, substance abuse, or overwhelming stressors. A crisis can involve an individual's perception or experience of an event or situation as an intolerable difficulty that exceeds the individual's current resources and coping mechanisms, and may include unusual stress in his or her life that renders him or her unable to function as he or she normally would. The crisis may not necessarily result in an upward trajectory or intensity culminating in thoughts or acts that are possibly dangerous to himself, herself, or others, right? A reasonable police officer is recognizing that the crowd is in crisis, that all of these things, the members, the bystanders, the citizens, whatever you want to call them, they are in crisis. So a reasonable police officer considers his department's training. What are these potential signs of aggression that I may be confronted with? Somebody standing tall, somebody red in their face, raised voice, heavy breathing, tense muscles, pacing, right? This is from the crisis intervention training. This is what Kerr Yang testified to. These are signs that police officers are trained to look for in a crisis as potential signs of aggression. How do you respond to those? You appear confident in your actions. You stay calm. You maintain space. You speak slowly and softly, and you avoid staring and eye contact. Again, these are things that Kerr Yang discussed in terms of how to deal with a crisis. As this crowd grew more and more upset or deeper into crisis, a very critical thing happens at a very precise moment. And I cannot, in my opinion, understate the importance of this moment, the critical moment in this case. If you recall from Dr. Tobin's testimony, nobody disagreed, that Mr. Floyd took his last breath at 8:25:16. 8:25:16. What is happening at the very precise moment that Mr. Floyd takes his last breath? You're taking one piece of evidence and you're comparing it against the rest. This moment, 8:25:16, as Mr. Floyd is taking his last breath.
Get over here. No, first of all.
But look, when you check on him, he's not responsive right now.
Look at him.
Get off the street. He's not responsive right now. He's not responsive right now. He's not responsive.
Three things happen. Mr. Floyd takes his last breath. You see Officer Chauvin's reaction to the crowd is to pull his mace and shake it. He's threatening the use of force as is permitted by the Minneapolis Police Department policy. And Genevieve Hansen walks in at that time from behind him, startling him. All of these facts and circumstances simultaneously occur at a critical moment. And that changed Officer Chauvin's perception of what was happening. After this point, the crowd grows louder and louder, right? And at this point now, Mr. Floyd has taken his last breath, and the question is the rendering of medical aid. When do we stop CPR according to the Minneapolis Police Department's policy? When it's not safe. You heard Lieutenant Mercel talk about this, and you also heard Nicole McKenzie talk about this. Consider Nicole McKenzie's testimony. As far as the reasonable police officer, which would include Nicole McKenzie, she discussed at length the difficulty of performing CPR in what she would describe as, or she did describe as, a hostile environment. You miss signs. Agonal breathing can be confused for effective breathing. As she testified, People in the area can affect the decision to treat a subject at the scene. She described how it is incredibly difficult to perform EMS efforts in a loud crowd, difficult to focus when you don't feel safe, makes it more difficult to assess a patient, makes it more likely that you can miss signs that a patient is experiencing something. So the distraction, she said, can actually do harm to a patient. When we're talking about this critical decision-making model, right? As Lieutenant Mercel said, he testified, sometimes you have to take into consideration whether it is worth the risk to remove the handcuffs and render medical aid, because it's unpredictable, right? All of this information is coming at a reasonable officer. The reasonable police officer standard can also be extended to Officer Chang, right? What is his perception of the crowd? You heard him testify, but you can also look at what was he doing during this time?
Shawanda. What was that? I said, y'all go one of the store guys. Okay, let's stay put. We'll figure it out, right?
Right. You've got Officer Chang pacing, turning around 360 degrees, right? His attention is focused on what's happening with the crowd. But he also has another job, right? Reasonable police officers and how they interact with the crowd is a consideration. You can also take into consideration the reactions of Shawanda Hill and Maurice Hall.
They gotta push him in this car. Look, he's fighting to get out. That's total resistance. What is he doing? Now he's going to jail. All he had to do was now the nigga going to jail. Look, they still fighting. Hey. Oh man, what is he doing? Oh, they going all around.
Not a police officer and their reactions to what's happening. But also consider the paramedics, right? The paramedics. They did the load and go, right? As Derek Smith testified, he got out of the ambulance, he checked all four corners to gauge what was happening and determined, in his words, that it was an unwelcoming environment. And he told his partner they needed to move to a different location, a more safe and secure location. Remember Nicole McKenzie's testimony too. As unreasonable as it sounds, paramedics get attacked too. We have all of these different opinions in terms of the use of force, right? We have all of the opinions of Seth Stoughton, Jody Steiger, Barry Broad, Zimmerman, Arredondo, David Pluger, Lieutenant Mercel, and they all reach very different conclusions about when the force became unreasonable. All you have to know about Barry Broad is what he was talking about is this physically managing any person. His opinion was you can use non-deadly force to physically manage a person. It's all within the model of the MPD decision-making model. I found the most interesting person to be relevant to the use of force, Lieutenant Johnny Mercel, considering that he is Derek Chauvin's actual use of force trainer. So the best glimpse that we're going to get into the training of a Minneapolis police officer comes from the trainer who conducts the trainings. He's conducted hundreds of trainings over the years. He corrected the state at certain times in terms of how strike charts don't apply to restraint techniques. He said the knee on the neck is not an unauthorized move, and it can be utilized in certain circumstances. He described using a knee on the neck and back and stated that it can be there for an extended period of time, depending on the level of resistance you get. He said that once the suspect is handcuffed, it does not necessarily mean that it is time to move your leg, because when people are handcuffed, they can thrash around and continue to be dangerous to themselves and others. He talked about the ground defense program because it's safer for both the suspect and the officer. He talked about ground defense as a form of using your weight to control a subject and therefore replacing the need to punch or strike them. He said there's no strict techniques. You need to be fluid and adapt to the circumstances. That he personally trains officers to put a knee over the shoulder, up to the base of the neck, and he described this maneuver as routinely trained by the Minneapolis Police Department. He testified that there are circumstances that an officer would need to use his weight to continue to control a subject. He recognized the concept of awful but lawful, right? Sometimes the use of force is just not that attractive. He's experienced himself arresting people who have claimed to have a medical emergency. He explained how one way people can resist is through their words. He described how someone resisting can become passive and then become resistant again, and vice versa. He discussed how officers are trained not just to focus on the subject, but also the bystanders. He trains officers that if you're fighting with a suspect and that person then becomes compliant, it is a legitimate consideration for the continued use of force to control a subject. That if a subject overpowers more than one officer at a time, that is a legitimate consideration in the continuation of the use of force. He talked about substance abuse and how that officers are trained, right? I understand that superhuman strength is not a real phenomenon. I know there are no Supermen or Spider-Men, right? But officers are specifically trained that someone under the influence of certain types of controlled substances exhibit this behavior. They become stronger than they normally would. We've all heard the anecdotal stories of the pregnant mom lifting the car off of someone, right? It's not literally describing a superhero. It's simply describing that someone is exhibiting a greater strength. And the Minneapolis Police Department specifically trains that. He trains on neck restraints. Minneapolis Police Department has a specific written policy on the use of neck restraints, and it was permitted, even though this wasn't a neck restraint or a chokehold. He talked about how you need to cut off the blood supply for a neck restraint to both sides of the neck. He talked about how someone whose heart rate is beating faster, they go unconscious quicker, less than 10 seconds. He described the human factors of force. That is, how does the use of force affect the officer himself, his cognition, his abilities, his mental and physical state. He agreed that not using the MRT is a form of de-escalation. He described that sometimes you have to use your body weight to control a subject until the scene is code 4. He said that Minneapolis will train officers that under certain circumstances, an officer can hold a person in the prone position until the scene is safe. And he's done it himself at times. You have to take into consideration the presence of bystanders, where officers are located, and the environment that they're in. Lieutenant Mercil agreed that there are circumstances where I talked about this a little earlier ago, where you have to make a decision, is it worth the risk to take the handcuffs off to perform medical aid? He said there are circumstances where you wouldn't put someone in a recovery position, depending upon the safety of people, including the crowd. while awaiting EMS. He described how crowds can make situations chaotic. He said, simply because a person is not actively resisting, that does not mean that you cannot use force. Right? Doesn't mean that you cannot use force. Simply because someone isn't stabbing you or punching you or shooting at you, it doesn't mean that you can't use force. And that is specifically in the Minneapolis Police Department policy on the non-deadly use of force that we've looked at a couple of times. The use of force is an incredibly difficult analysis. You can't limit it to 9 minutes and 29 seconds. It started 17 minutes before that 9 minutes and 29 seconds. All of this information has to be taken, you have to look at it from the totality of the circumstances. You have to look at it from the reasonable police officer standard. You have to take into account that officers are human beings, capable of making mistakes in highly stressful situations. In this case, the totality of the circumstances that were known to a reasonable police officer in the precise moment the force was used demonstrates that this was an authorized use of force, as unattractive as it may be. And this is reasonable doubt. Steiger talked about being on the panel, right? They have 5 officers on a panel to assess whether uses of force are reasonable. Sometimes it's 4-1, sometimes it's 3-2, sometimes it's 5-0, because the reasonableness of the use of force is not an easy thing to consider. I know, again, I'm sorry, I'm long-winded. There are a couple of other things I need to talk about very briefly. I promise I'll be as brief as I can before I get to the cause of death. First is that concept of intent. As the state showed you, with respect to counts 1 and 2, you have to address Mr. Chauvin's intent. Pay careful attention again to the instructions. Words have meaning. Intentionally or intentional means that the defendant either has the purpose to do the thing or cause the result specified, or believes that the act, if successful, will cause the result. In addition, the defendant must have knowledge of those facts that are necessary to make his conduct criminal and that are set forth after the word intentionally, intentional. It's the same, you'll see a very similar instruction. You'll see this very similar instruction twice. Intent. Did Officer Chauvin intentionally apply unlawful force? That's what you're being asked to decide. Did he purposefully apply unlawful force to another person? In count 2, you have to decide, did he purposely perform an act? Did he intentionally perform an act that was eminently dangerous? Right? What considerations do you have at your disposal? What pieces of evidence do you have? I'm going to try to go through these quickly. What evidence is there? What evidence is inconsistent with intent? Some facts and circumstances that are important for you to decide in terms of his intent is within the context of aiding and abetting other people. First, officers know that they are being videotaped. They know they're being videotaped by themselves. They know they're being videotaped by bystanders. They know they're being surveilled by the Minneapolis Police Department milestone camera, right? They know these things. Do you do something purposefully that you know is an unlawful use of force when you have 4 body-worn cameras immediately in the area where you have multiple civilians videotaping you, where you know your actions are being reviewed through a city-owned camera, where there are surveillance cameras? Do people do things intentionally and purposefully when they know they're being watched? Remember, Officer Lane offered to have, when they were putting Mr. Floyd into the squad car, he said, "I'll sit with you. I'll put the window down. I'll turn on the air conditioner."
What's up, man? Please. I'm just claustrophobic. That's it.
Well, you're still going in the car.
Anything sharp on you? I won't do nothing to hurt y'all. No, sir.
Now you want to get home or nothing?
Nothing. I don't have nothing. Why y'all doing me like that, Mr. Officer? Please crack it doing it for me and stuff, man. I am claustrophobic for real, Mr. Officer.
You got him?
Could you please crack it for me, please?
Yes, I'm cracking.
Stay with me, man.
I will.
Please stay with me, man. Thank you. God, man. I didn't know I was going to happen, man. Please, man. I just want my hands, please. I don't want to do none of y'all, man. Nothing.
You got it?
Inside in the pocket real quick, sir.
I'm listening. And I understand that people do stuff.
All right, it's good. This comes with it. There's nothing worth
Okay.
Grab a seat.
Have a couple waters out because that was my smile.
I'll roll the windows down, okay?
Please, man. Please don't do that.
Take a seat.
I'm going in, Mr. Officer. I'm going in.
No, you're not.
I gotta go in.
Take a seat.
Grab a seat, man.
Mind, y'all don't believe me, Mr. Officer.
Take a seat.
I'm not that kind of guy. I'm not that kind of guy, man.
Take a seat.
Y'all, I'm gonna die here.
Take a seat.
I'm gonna die, man.
You need to take a seat right now.
And I just had COVID, man. I don't want to drink to that.
Okay, I'll roll the windows down. Hey, listen.
Dang, man.
Listen.
I'm not that kind of guy.
I'll roll the windows down and
Please,
you put
man.
your legs in, all right?
Y'all
I'll put the air on.
stop. Look at that. Look at that.
Not even listening.
Look at it. Look at it.
All right. I'll roll the window down 3 times. I'll turn on the air conditioning. Is that evidence of intent to apply unlawful force? Officer Chauvin confirms that Mr. Floyd is under arrest.
Take a seat. Please, man. Please listen to me.
Is he going to jail?
Listen to me.
He's under arrest right now for forgery.
I'll tell you.
Can we figure out what's going on?
Forgery for what?
Take him out.
For what? Please, man.
Officer Chauvin made a decision not to use higher levels of force when he would have been authorized to do that, including punches, kicks, elbows, right? All of these tools were available to Officer Chauvin. That is not an intent to purposefully use unlawful force. They call for EMS within 1 minute of putting him on the ground. They step it up within another minute and a half. He believes that Officer Chauvin believes that Mr. Floyd's ability to speak means he can breathe, and they say it repeatedly, remember? Excuse me. They tell him to relax.
You're the arrest guy.
All right. Oh, my God.
Sorry, go to jail.
I can't believe this.
Officer Chauvin is never swearing at him. He's not calling him names. All of this stuff that we've already talked about, and I don't need to go through this again. All of this stuff that we've talked about throughout the entirety of this circumstance does not reflect an intent to purposefully, intentionally commit an unlawful use of force. All of the evidence shows that Mr. Chauvin thought he was following his training. He was, in fact, following his training. He was following Minneapolis Police Department policies. He was trained this way. It all demonstrates a lack of intent. There is absolutely no evidence that Officer Chauvin intentionally, purposefully applied unlawful force. Officer Chauvin is also refocusing the other officers, telling them they need to do things to pay attention to Mr. Floyd. Should I put his stuff in the car? No, we need to get him in the ambulance. Let's refocus, right? Officer Chauvin had no intent to purposefully use, or he did not purposefully use unlawful force. These are officers doing their job in a highly stressful situation. According to their training, according to the policies of the Minneapolis Police Department, and it's tragic. It's tragic. They go to the hospital. They perform CPR. They call their supervisors. Was this an eminently dangerous act? Was putting Mr. Floyd an eminently dangerous act? We've heard a lot about the prone position. Consider just the basic prone position. People sleep in the prone position. People suntan in the prone position. People get massages in the prone position. The prone position in and of itself is not an inherently dangerous act. It is not an inherently dangerous act. A prone position during restraint is not an inherently dangerous act. It is routinely trained and used by the Minneapolis Police Department. The studies show, right? Canadian studies that were referenced by Dr. Fowler. 1,269 cases, use of force, one death of a person not in the prone position. Right? These are people, they're looking at people in the prone position. 4,828 consecutive force events. No significant clinical effects on the subject's physiology. Right? We can look at all of the other studies trying to determine this question is putting a subject in the prone position, even with officers on top, even with weight on top of the person, is that inherently dangerous? And the research says no. The practical experience says says no. The prone position, when applied through a use of force, is not an eminently dangerous act because there is no evidence to support the notion that it was highly likely, that's the standard, highly likely to cause death. There's reasonable doubt about that. So let's talk about the cause of death. And again, I'm sorry to be long-winded, but I have to address the cause of death. Because the state neglected to read perhaps one of the most important sentences from the instruction, and why you must read the instruction carefully. Yes, the defendant is criminally liable for all of the consequences of his actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes. If such intervening causes were the natural result of the defendant's act. Okay? So if the intervening causes were the natural consequences of the defendant's acts, he's liable. So think about it in this example. Police officer arrests somebody. He puts that person on a hot August afternoon in the back seat of a squad car, rolls up the window, turns on the heat, and leaves the person in there, right? Person dies of a heat stroke. Officer put him in there and is responsible for the natural consequences of his actions. But consider the situation where police officer arrests someone, they're compliant, they go into the back seat of the squad car, they're sitting in the back seat of the squad car, and they have a heart attack. They have a pulmonary embolism. They have a brain aneurysm. Something happens to that person that was not the natural consequence of being arrested. It was just a physiological something that happened to that individual The officer is not liable because it's not in the natural course of events, and it's not the result, the natural result of the defendant's act. Right? So again, read the entire instruction. The significance of this instruction, again, is that it goes through all of the 3 charges. You have to be convinced that the defendant's actions caused the death of Mr. Floyd. And throughout the course of this trial, the state has tried and called numerous witnesses to try to convince you that asphyxiation is the singular cause of death. The singular cause of death. And why is that? It's because actions that happened before Mr. Floyd was arrested that had nothing to do with Officer Chauvin's activities are not the natural consequences of the defendant's actions. You have to focus on the consequence of the defendant's acts. And so the state has tried to convince you beyond a reasonable doubt that the stress of being arrested and the adrenaline produced as a result of Mr. Floyd's physical resistance played no role. This is what they have to try to convince you. There's no role of that physical exertion, played no role in this death. They're trying to convince you beyond a reasonable doubt that Mr. Floyd's heart disease played no role in this case. The state must try to convince you beyond a reasonable doubt that Mr. Floyd's history of hypertension played absolutely no role in the cause of Mr. Floyd's death. The state must convince you beyond a reasonable doubt that Mr. Floyd was not experiencing excited delirium that contributed to the cause of his death. The state has to convince you beyond a reasonable doubt that Mr. Floyd's paraganglioma was not contributing to the cause of death. The state must convince you beyond a reasonable doubt that Mr. Floyd's toxicology played no role in his death. Right? The state would have to convince you beyond a reasonable doubt that a combination of these pre-existing issues did not contribute to Mr. Floyd's death. That is why the state has brought in expert after expert after expert to testify that the singular cause of death here is asphyxiation. Because if Mr. Floyd was asphyxiated as a result of the police restraint, he is liable for the natural consequences of that restraint, of his actions. But if any of these other factors come into it, if any of these other factors were substantial contributing factors of Mr. Floyd's death, because they were not the natural result of the restraint. If a person has drugs in their system and that drug causes an overdose in the context of the police restraint, it's not the natural consequence of the restraint, it's the natural consequence of the deceased's actions. So the state has called 6 experts, really 5, but I'll include Dr. Baker. The state first called Dr. Tobin, a pulmonologist. Dr. Tobin said that you need to apply common sense to the evaluation of the medical testimony. He testified that Mr. Floyd died exclusively from positional asphyxia, coronary artery disease, hypertension, controlled substances. They played absolutely no role in the death, according to Dr. Tobin. The state called Dr. Eisenschmidt, a toxicologist, to explain to you that Mr. Floyd's toxicological levels were somehow more consistent with a DWI case than a whole bunch of other cases that may or may not have involved an overdose. Right? remember the ratio where you said, well, no, these are cases, they may have died of something else. They may have died of a gunshot wound, but they had fentanyl in their system. So he gave you these strange statistics, but essentially attempting to try to convince you that these levels are insignificant. People drive their cars around, right? And that therefore the drugs played no role in the death of Mr. Floyd. Third, the state called Dr. Smock, an emergency room physician, right, to explain to you that Mr. Floyd was not experiencing any symptoms of excited delirium. And that coronary artery disease, hypertension, controlled substances, none of that comes into play. He called Dr. Thomas, a pathologist, to testify how she interpreted what Dr. Baker meant. How she concluded that Dr. Baker simply said that the cardiopulmonary arrest is the basic way everybody dies. And she interpreted the reason why Dr. Baker put those factors on his autopsy or on the death certificate were merely for statistical purposes. You put stuff, the CDC requires us to put that stuff on there. And it was an asphyxial death. Controlled substances played no role. Hypertension played no role. Coronary artery disease played no role. They did call Dr. Baker. And we'll talk about Dr. Baker in a minute. And finally, the state called Dr. Rich, a cardiologist who concluded that despite a 90% narrowing of the right coronary artery and a 75% narrowing in the left anterior descending artery, despite an enlarged heart and a history of hypertension, that Mr. Floyd had a strong heart, and that none of those pre-existing and coexisting conditions in any way contributed to the death of Mr. Floyd. I submit to you that the testimonies of Dr. Tobin, Eisenschmidt, Schmock, Thomas, and Rich, it flies in the absolute face of reason and common sense. It's astounding, especially when you consider the actual findings of Dr. Baker, right? Because Dr. Baker is the only person who actually performed the autopsy in this case. He's the only person who performed the actual autopsy. He told you that he specifically avoided watching the video because he didn't want to bias or influence his autopsy. He specifically testified that there was no evidence of asphyxia. There were no evidence of petechial hemorrhaging. There was no bruising to the neck or back above the skin, under the skin, or into the subcutaneous muscles of the neck and back. And he would expect to see those things in a case like this. There was no finding that pressure was applied to the point of Mr. Beck to cause these injuries. There were no injuries to the structures of his neck, and that when he finally did review the video, it didn't appear that the placement of the knee affected the structures of the neck because Mr. Floyd could lift up his head, turn his head, move it around. He saw no fractures to the structures of the neck, including the hyoid bone. There were no soft tissue injuries to the sides of Mr. Floyd's neck. There was no hemorrhaging or injury to the hypopharynx. No evidence of life-threatening injury to the neck or spinal column of Mr. Floyd. There was pulmonary edema, which is the swelling of the lungs, which could be caused by the resuscitative efforts or fentanyl. There's no evidence of hypoxic changes to the brain. There's no evidence of any brain injury consistent with an asphyxia death. He found a paraganglioma, and he said it was an incidental finding. He said his heart was enlarged. Mr. Floyd's heart was enlarged, right? Dr. Baker, Dr. Thomas, Dr. Rich, and Dr. Fowler all agreed. He found narrowing of the right coronary artery, 90% narrowing. He found 75% narrowing of the left anterior descending artery. He's the person who did he sent out the toxicology samples. Fentanyl level at 11 nanograms per milliliter. Methamphetamine at 0.19 per millimeter. All of these findings that are ultimately relied upon by all of these other experts were done by Dr. Baker. He determined that the manner of death was a homicide, right? Homicide, homicide, homicide. But read the definition again of the medical definition of homicide. It is to be emphasized that the classification of homicide for the purposes of the death certificate is a neutral term and neither indicates nor implies criminal intent, which remains a determination within the province of the legal processes. Right? The fact that he found this a homicide is a medical term. Dr. Fowler talked about the undetermined manner. Could not be determined is a classification used when the information pointing to one manner of death is no more compelling than one or more other competing manners of death in or through consideration of all available information. Dr. Baker found the immediate cause of death and the other contributing factors. Cardiopulmonary arrest complicating law enforcement, subdual, neck restraint, and neck compression. Other contributing factors are arteriosclerotic and hypertensive heart disease, fentanyl intoxication, and recent methamphetamine use. The term complicating in this is important because Dr. Baker was able to give you what he said his actual intent was, right? Dr. Thomas speculated about what she thought Dr. Baker meant. Dr. Baker was able to tell you what he meant. He defined complicating as an intervention that occurred. An intervention occurred and there was an untoward outcome on the heels of that intervention. And he gave you a specific example. He described a person having a hip surgery and a blood clot comes loose and that blood clot causes a death. The hip surgery didn't cause the death. The death was caused by the blood. So as I understand his testimony, what Dr. Baker was saying was that there was an unexpected result. The death of Mr. Floyd occurred during an event where you would not generally expect such a complication, subdual and restraint. He specifically testified, Dr. Baker specifically testified that if he put it on the death certificate, it played a role in the death. If something is insignificant to death, you don't put it on the death certificate. So Dr. Baker's conclusions that Mr. Floyd's arteriosclerotic and hypertensive disease played a role in the death of Mr. Floyd. Dr. Baker concluded that Mr. Floyd's fentanyl intoxication played a role. Dr. Baker concluded that Mr. Floyd's recent methamphetamine use played a role. Right? Dr. Baker described that this death of Mr. Floyd was a multifactorial process. A multifactorial process is how he defined it. No single factor, one over the other, played any more of a role resulting in Mr. Floyd's death. He said his heart simply couldn't handle it within the context of the subdual and restraint. Apparently, the state, as they just argued, wants you to believe what you see. And they did not like Dr. Baker's conclusions. And you can see the process Dr. Baker talked about when he had several meetings, right? This happened in March. Excuse me, happened in May, June, July. By August, talked to a pulmonologist. talk to an emergency room doctor. Not within my area of expertise. Talk to a cardiologist. Right? His findings didn't support the notion that what you see is what you should believe. And so the state did that. They went and hired Dr. Chauvin, right? A pulmonologist. Now, despite all of the information that Dr. Baker has concluded or found during the actual autopsy, Dr. Chauvin concluded emphatically that Mr. Floyd's death was the result of positional asphyxia, right? The pressure of the asphalt, pressure of the weight of the officers, the positions, all of this resulted in hypoxia, low oxygen to the brain. Mr. Floyd was asphyxiated through positional asphyxia. Remember at the beginning of my remarks, I asked you to perform an honest assessment of all of the evidence in the case. And I'm going to submit to you that with no other witness should this be more carefully analyzed. I want to illustrate two brief things that Dr. Chauvin testified about, and I want to illustrate how I think that these demonstrate a bias, because you still have to consider an expert witness in the context of bias. I'm going to call it the finger and knuckle testimony and the toe lifting testimony. You may remember this slide, right? That this slide shows George Floyd pushing his fingers against the street to lift his shoulder off the street. That he was pushing his knuckles against the tire. Right? He described what he interpreted this was basically Mr. Floyd trying to push himself up onto his left side to free the right lung to help him breathe. Look at the timestamp of the photos taken from the body-worn camera here. They were taken at 8:19:35, 15 seconds after Mr. Floyd was placed on the ground. Yet Dr. Chauvin also explained that Mr. Floyd went on to breathe for an additional 5 minutes and 51 seconds until he took his last breath at 8:25. He neglects the fact that at this point, this is the point that we just saw, when Mr. Floyd is taken out of the car and he is actually in the side recovery position for about the first 2 minutes of this 9 minutes and 29 seconds.
Not moving.
Mama. Mama.
Yeah,
Mama. Mama.
One of the front couches.
Mama.
On my right side back.
Mama. Mama.
You're the best guy.
All right. All right. Oh my God.
It's time to go to jail.
I can't believe this. I can't believe this. I can't believe this. I can't believe this, man. Mama, I love you. Reese, I love you.
You got a problem?
Just my kids, I love them. I'm dead.
Why is it my side? It's listed. It's
I can't breathe for nothing, man. It's cold blooded, man. Mama, I love you. I can't do nothing.
Yeah, EMS is on their way.
My face is gone. I can't breathe, man. Please. Please let me stay in.
No.
Please, man, I can't breathe.
Get up on the sidewalk, please. One side or the other, please.
My face getting bad.
Here, should we get his legs up?
Oh, that's all right.
Nope, just leave him.
Oh,
Just
my
leave him.
God.
Just leave him. Yep, just leave him.
All right.
I'm dead.
Hopefully Clark's still sitting on the car.
Look at my face, man.
How can you take, this illustrates how you can take a single nanosecond of time in this arrest. You can have this testimony that he's pushing his body up to try to breathe, right? But when you look at the evidence compared to the rest of the evidence, what do you really see? You see a person who is on his side, being held in the side recovery position, whose hand is touching the ground and the tire at times. You cannot take a single isolated frame and reach any conclusions, because much like the use of force, the cause of death has to be considered within the totality of the circumstances. And then you may remember this testimony. This is Officer Chauvin's foot off the ground. And he described how at this precise moment, Officer Chauvin was applying 91.5 pounds of pressure to the neck of Mr. Floyd. So let's look at this time in the context of the other evidence.
His whole nose was
Fought with him? Bro, why you just sitting there? He ain't doing nothing now. Put him in the car.
How long y'all gotta hold him down?
This is why we don't do drugs, kids. It ain't about drugs, bro. Y'all understand that?
Did anybody even see the toe come up off the ground? I mean, was it a half a second, a quarter of a second? Right? But when you take a single incident, a frame, a single frame, and you add the drama, and you make all of the assumptions, right? Officer Chauvin's body weight, Mr. Floyd's EELV. He's the only person who calculated the EELV based upon the presumptions of health, based upon studies, based upon theory. All of this information, you can put this into a single frame, but you have to analyze the evidence in the broader context. You can also see during the clip that Officer Chauvin actually is sort of adjusted forward and touches this car, right? You can make a lot of informed decisions about how is he shifted. If I'm shifting my weight this way, majority of my weight is shifting on my left foot. If I'm this way, it's on my right foot. You watch this video and you can see the dynamic shifting. And you can see the placement of the toes, right? The toe tucked under helps an officer maintain his weight, or helps any person maintain their weight. But a toe flopped over to the side, it's a little harder to balance. You cannot take a single frame and draw conclusions. You have to look at the totality. And remember, he said he spent 150 hours analyzing this tape. His entire testimony is filled with theory, speculation, assumption. Do not let yourselves be misled by a single still frame image. Put the evidence in its proper context. We have to talk about the toxicology. Again, we're not suggesting that this was an overdose death, right? It's a multifactorial process, as Dr. Baker said. So we have to look at what role does the toxicology play in this case. And you need, because again, we had Dr. Eisenschmidt who testified that he found that the levels of fentanyl and methamphetamine were more consistent with this DUI population. But what do we know about the actual toxicology? There were 11 nanograms per milliliter of fentanyl and 0.19 nanograms of methamphetamine. Those are the principal two findings. And additionally, what we know is that the byproduct of methamphetamine, which is amphetamine, was not reported at the level. Doesn't mean it wasn't technically there, but it was not reported. So it's below threshold reporting values, which signifies that the methamphetamine use was recent. Hence, in Dr. Baker's death certificate, he included the recent methamphetamine use because there was no amphetamine. The history of Mr. Floyd's use of controlled substances, it is significant. It's not a character problem. Millions of Americans suffer from the opioid crisis, right? I mean, it is a true crisis that this country is facing. But it is significant to understand the history, not just as much as the long-term history, but his long-term history provides us with insight on how his body physically reacts to methamphetamine or opioid use, I should say, opioid use within the context of a law enforcement encounter. We know from the testimony of Courtney Ross that Mr. Floyd struggled. We know he had been using controlled substances habitually for some time. We know that on May 6th of 2019, during an encounter with the police, Mr. Floyd ingested some controlled substances, said they were Percocets. He was startled by the police, like he was in this case. Officer drew his gun in that case too. And that resulted in a blood pressure of 216/160. I mean, that's not just high. That is skyrocketing high. We know from Ms. Ross that in March of 2020, they purchased some pills that were supposed to be Percocets, an opioid. But they were clearly knockoffs. She described that. They were clearly knockoffs. She described how those pills made her feel. They kept her up all night, right? The introduction of the methamphetamine. We know from Ms. Ross that in March of 2020, Mr. Floyd was seen for a drug overdose. She described how he felt in that instance. She said his whole body hurt. His stomach hurt. We know, based on, again, from Ms. Ross, that he was clean and sober for some time while they were in quarantine. We know that Ms. Ross again described taking about a week before a similar pill to the one that they had back in March. Kept her up again all night, right? She said she felt like she was going to die. We know, again, from Ms. Ross, that those pills were purchased from Maurice Hall. She described going to a hotel. While Mr. Floyd went into the hotel, she was on the phone with him. She heard Maurice Hall's voice. We know Mr. Floyd was with Maurice Hall on May 25th, 2020. We heard from the store clerk, Christopher Martin. He described Mr. Floyd as being high. His responses were delayed, right? He may have been, standing around. He may have been standing up. He may have been able to have communications. But Mr. Martin clearly described him as being high. We heard from Shawanda Hill that when they got back into the car, right, they had a conversation for a few minutes, and suddenly Mr. Floyd fell asleep. All of these things become important. That he had trouble. They had trouble waking him up. She called her daughter for a ride because they couldn't wake Mr. Floyd up. They couldn't keep him awake. We heard how Mr. Martin described Mr. Floyd when he went back to the car and how he was, no, and he wasn't speaking, right? But he kept putting his head back and shaking his head. We know from Peter Chang's body-worn camera that Maurice Hall also described that Mr. Floyd was dozing off.
He got jealousy because he was falling asleep a little bit, and then when he woke up, they was up at the door.
Right? We know that whether Mr. Floyd was chewing gum while he was in the store, we can also see he was eating a banana. Right? He bought a banana. So we know when we look at this picture, right, there's something in Mr. Floyd's mouth. Is it gum? Is it banana? Is it drugs? Nobody knows, right? But regardless of whether it's drugs, bananas, or gum in this incident, we know that there were pills in the car, right? We know that there were drugs in the car. We know those pills were later tested to be a combination of methamphetamine and fentanyl. That's what was in Mr. Floyd's system. It's relevant because it's what was in his system. These are the pills that were found. We know at some point Mr. Floyd was handcuffed. His hands were behind his back. It would have been physically impossible to put anything in his mouth at that point. And we know that in the squad car, 320 were pills. We know those pills were analyzed. We know those pills consisted of fentanyl and methamphetamine. We know that Mr. Floyd's salivary DNA was found on those pills. How much fentanyl does it take to kill? This is from the Minneapolis Police Department's training. Approximately 2 to 3 milligrams. Smaller than a penny. This is from the squad car. You can look at these pictures closely during the course of your evidence. There is a video of Mr. Floyd when Mr. Floyd is being subdued by and restrained by the police. Mr. Maurice Hall reaches into his bag. He's looking through the windows. We watch it. And then he throws something. Right? We know that Mr. Floyd had drugs in his mouth. We know that some percentage of that would have been consumed and absorbed into his system. We don't know how much he took before, right? We don't know when he took an earlier dose in relation, because fentanyl had actually started to metabolize in his, so fentanyl was longer before. For the medical experts to minimize the timing and the amount of illicit drugs that were found in Mr. Floyd's bloodstream, it is just simply incredible to me. It is incredible to me. Every single doctor testified that relevant to that the absence of signs of fentanyl overdose weren't present because he was alert, he was talking. But it ignores what Shawanda Hill and Maurice Hall says, right? That he was all of a sudden asleep and difficult to wake up. It ignores the fact that the combination of these two drugs, methamphetamine is a powerful stimulant. Fentanyl is a powerful sedative. They use it for surgeries. Every single doctor dismissed outright. No, nothing about this case. Well, it was only 0.19 grams, nanograms per milliliter. It's such a small amount of methamphetamine in his system. It's a vasoconstrictor. It causes the heart's arteries to constrict even tighter. Doesn't matter. Every single doctor just brushed it aside, said it would have no effect. I ask, would any of those doctors prescribe illicit methamphetamine to their patients? Would they give it to their children? Would they give it to their elderly parents with a 90% blockage of the coronary artery, the right coronary artery? I guarantee you the answer is no. Dr. Rich is the only one who said, I would never recommend to my patients that they take any amount of illicit methamphetamine. It is preposterous that it is a preposterous notion that this did not come into play here.
Half-hour break for lunch. I don't want to interrupt your argument, but
Thank you. I apologize. It's
members of the jury, 30 minutes for lunch, please. Thank you.
All right, this is Kate Snow with you in New York. We have been listening for more than 2 hours now to the closing arguments from the defense attorney. We've been hearing there from Eric Nelson laying out his perspective on this case. This is the Derek Chauvin trial on charges of murder and manslaughter. We have a number of people with us. The judge just said he'll take 30 minutes for a lunch break, and then the defense will continue, presumably, because that attorney was not quite done with his closing arguments yet. Let's start with NBC's Gabe Gutierrez. He's been following the trial all the way through. He joins us from outside Hennepin County Courthouse, where everything has been underway. Gabe, I thought there were a number of interesting things. Number one, the overall point that he seemed to make was that don't just pay attention to the 9 minutes and 29 seconds when Derek Chauvin's knee was on George Floyd's neck and he was on the ground. Don't just look at that. Look at the totality of the scene and what those officers were confronting.
Yeah, that's right, Kate, and that is something that defense attorney Eric Nelson has said since the beginning of this trial. During opening statements, urging that same thing from jurors to not just pay attention to that 9 minutes and 29 second period that was in that viral cell phone video that was watched around the world. But in this closing argument, Eric Nelson also played snippets from the body camera videos of those other officers, and he said the 9 minutes and 29 seconds ignores the previous 16 minutes and 59 seconds, essentially arguing or wanting jurors to look at the totality of the situation that was unfolding. He also mentioned several other things, Kate, including talking about that this was an unauthorized use of force, as unattractive as it may be, and that these were officers doing their jobs in a highly stressful situation. It's tragic, he said. But Kate, this is a very long, lengthy closing argument from Eric Nelson's, now clocking in at around 2.5 hours, and now this break for lunch. But he is trying to shift the focus away from that video, Kate, and during that closing argument, you saw Derek Chauvin, during a rare part in this trial, actually viewing his attorney speaking with his mask off. Of course, Derek Chauvin did not testify during this trial, so this may be some attempt on the part of the defense to try and humanize him a bit. But again, this ongoing closing argument where Eric Nelson is trying to shift the focus away from that 9 minutes and 29 seconds, arguing, as you just heard there, about the cause of death and trying to throw some reasonable doubt in the minds of the jury, Kate.
Yeah, Gabe, we were showing a picture there, a side-by-side of Derek Chauvin with the mask on for COVID reasons. That's how he's been throughout much of this trial. And then without it on, he took it off. We went back and looked. He took it off just as his attorney began presenting closing arguments. Let's turn to criminal defense attorney, NBC News legal analyst Danny Savalos is with us. Danny, we talked about what we were anticipating. He certainly tried at every turn to create reasonable doubt in what the prosecutors have presented.
I have to wonder, and we'll never know the answer for sure, but I suspect the prosecutors are sitting during the break looking at each other and saying, can you believe he played all that video? They must be thinking that helped them, because however much the defense needed whatever evidence was in that video to play it for the jury in closing, it acquired risk in that the jury is again hearing George Floyd plead for his life, say he can't breathe, hear bystanders tell the police to lay off because George Floyd can't breathe. You know, the defense is in a tough position here. They have certain evidence in those videos that they must have felt they needed the jury to hear again in closing. But of course, by playing that video again, the jury is seeing that video again. And the video has always been the very best evidence in the possession of the prosecution.
Yeah, it was interesting how much he relied on video. And Danny, I noticed that it was almost never video from the perspective of Derek Chauvin. It was never video of Chauvin with his knee on George Floyd. It was always from the other officers on the scene to try to show, as he would say, more context.
That's right, exactly. But that video has an audio component, and you can hear George Floyd throughout that video. And you even hear sometimes Derek Chauvin saying some of the things that the prosecution felt was helpful to their case. So, yes, you're absolutely right in that the defense carefully cherry-picked the video that would be helpful and avoiding showing a knee and avoiding showing a neck whenever possible. But some of that audio filtered in, and it's, again, that repetition. And repetition is something that gets emblazoned in jurors' heads. And if they hear this pleading for the life over and over again, it might just sink in. And don't forget, the prosecution has another shot to come back in. And usually this last word is where they really go all out. And they get very dramatic and have a lot of flair that they may not have had on the front end for their first go-around.
Danny, thank you. And we're going to hear from, we suspect, we're going to hear from a different attorney for the prosecution once they get that rebuttal. But first, we're taking a lunch break per the judge. The jury is taking a lunch break. After that, we expect that the attorney for Derek Chauvin will continue and finish his closing arguments before we get to that prosecution rebuttal, which will be the last word before the jury gets the case. I want to bring in Mary Moriarty. She's the former chief public defender for Hennepin County, Minnesota, so right there in Minneapolis. One of the other things that you heard the attorney for Derek Chauvin repeating over and over again is, what would a reasonable police officer do? He must have said that 100 times, a reasonable police officer. Walk us through what he's trying to get those jurors to think.
Well, it's kind of like during his cross-examination where he would come up with hypotheticals, where he would say, you know, wouldn't it be reasonable for a police officer to seek cover if shots were being fired at them before rendering care? And it came across like that because he started talking about what a reasonable police officer would do before Officer Chauvin even arrived at the scene. And he spent a lot of time talking about what happened before the 9 minutes and 29 seconds. Which I think is problematic because the critical point here is the 9 minutes and 29 seconds. I can also tell you this is the longest closing argument I have ever heard here. I can tell you I have never seen a judge interrupt a defense closing to take a break like this. I think the judge is really annoyed by it. And he took a half-hour break to give the jurors lunch because the defense closing argument was going on so long.
Yeah, that is very interesting. Just as a practical matter, it is 2:17 right now in Minneapolis. It's well past when they would normally take that lunch break. Thank you so much for staying with us for this. Let me go over to Joyce Vance, NBC legal analyst, who's back with us. If you've been with us all day, she's been with us all day as well. Joyce, what do you think prosecutors will have to do when they get that rebuttal after this lengthy defense closing argument?
The most important things that the prosecution can do is obliterate any notion that there is reasonable doubt and then leave the jury with a moral certainty that justice can only be achieved if they return a verdict of guilty. Those are your jobs in closing argument as a prosecutor. And I was listening to Danny's comments earlier, his concern that prosecutors would be really happy that the defense played the videotape over and over during its closing argument. I think Danny is absolutely right here. The defense took some gambles in trying to create reasonable doubt. I don't know if they will pay off for them, particularly replaying that video. And this notion that the defendant was behaving reasonably, that his use of force was not excessive, which would be a good defense. But one of the things that they said was Police officers are trained to know that if someone can talk, they can breathe. That leaves an opening for the prosecution to come back in closing and look the jury in the eye and say, at some point, George Floyd was no longer speaking, and Derek Chauvin's knee was still on his neck. It feels like the defense has left the prosecution too many opportunities like that to remove the sense that there's reasonable doubt. Maybe there's speculative doubt, but that's not what reasonable doubt needs. And the prosecution will hammer home the need to achieve justice here on behalf of George Floyd.
Joyce, thank you. I'd like to get the perspective of a former police chief of Seattle. NBC News law enforcement analyst Carmen Best is still with us as well. Carmen, one of the things that struck me was that they were talking about the question of why an officer would use unreasonable force if he knew that all these bystanders were around taking video. And just your perspective also on the question of how hard it is, how difficult it is to be a police officer. That was raised again and again. We don't necessarily know all the facts, was what that lawyer was trying to suggest.
Yeah, it was very interesting to listen to the defense. He kept going on about what a reasonable officer would do. A reasonable officer would look around the area. A reasonable officer would pay attention to the crowd. A reasonable officer would modulate, the force and the, taking Mr. Floyd's hands. He's absolutely right. A reasonable officer would do that. But a reasonable officer also would stop at the point that they were not meeting resistance. I mean, so he gave part of the answer, but because we all can agree reasonable officers would do these things. And also, based on the testimony of all the officers from Minneapolis that came forward, as well as the chief, a reasonable officer would make the decision to discontinue that level of force under those circumstances. So he cut that sentence short, in my view, trying to portray what reasonableness is, when in fact a reasonable officer, a reasonable human being, would not continue with those actions with the person begging for their life and saying that they couldn't breathe. So I thought that was interesting that he would bring up that point, but he really didn't finish the thought that would go along with it. And I'm sure that the prosecutors will pick up on those pieces as well.
What about the idea, though, that there were bystanders all around videotaping, and the argument from the defense that why would he use unreasonable force if he knew he was being videotaped?
Well, I mean, that is an interesting question, but quite frankly, from my opinion, I've been a chief. I've issued a lot of discipline. The arrogance on his face as he was on Chauvin's face as he sat there with his knee on Mr. Floyd, looking arrogantly out at the crowd, basically showing them, he's not going to listen and he's boss. These are my opinions. I've looked at, dozens of cases, and I absolutely think that had a highly contributing factor to why he continued, even with all the cameras out there. Look, we have seen case after case where things haven't gone right in interactions, and they're on video, and the officers are wearing body-worn camera. So that is not unusual for something to be caught on camera in one of these types of incidents.
Yeah, we've certainly seen many just in the last week. Carmen, thank you so much. Let's go to NBC News contributor Eddie Glaude. He's an NBC News contributor, and then we also have NBC News political analyst Eugene Robinson with me, joining me now. Appreciate both of your perspectives on all of this. I think about where the nation is at this moment. The White House this afternoon has said that they're preparing potentially a statement for whatever this verdict will be. The nation is really on standby, on hold, waiting for this. What's your perspective on how significant this moment could be?
Which one of us?
Eddie, I'll put that to you. Sorry.
Sure. It's policing has always been at the center of the question of race in this country. It has everything to do with the generalized sense of disregard that many black people feel in this country. And what was striking about the defense is that, he says, remember the prosecution said, what you saw happened. Believe your eyes. And then the defense said, don't believe what you see, right? Don't believe what you saw. Right. And then the next thing he said is that the natural consequences, that George Floyd died of the natural consequences of the deceased. He was the reason why he died. And those sorts of justifications carry with them the burden of history, right? The burden of history of race and policing in this country. So in some ways, the trial represents the American tragedy because policing takes us to the heart of this generalized sense of disregard that has defined this place for generations.
And Professor Glaude, are you, as we sit here, are you concerned about what may happen? Are you, we're hearing reports this afternoon that Facebook, for example, is monitoring and trying to make sure that they don't allow, dissemination of posts about violence. Are you concerned about the country?
Well, yes, absolutely. I'm not the only one concerned. You see National Guard activated. You see police on alert. There's a sense in which we should not only be concerned about the nature of protest, but we should be concerned about the systemic practices that generate the protest. Since Obama's commission in 08, since the Obama commission during the 08 and his two administrations to now, think about all the bodies. Think about all the parents who had to bury their dead. So we have to finally resolve this issue. So, of course, I'm worried, but we need fundamental change here. Fundamental.
Eugene Robinson, a last comment from you. What are you looking to this afternoon?
Well, first of all, the defense attorney Nelson's closing being so long and taking so many risks, frankly, in airing all that videotape, had the air to me or the sense of almost a Hail Mary. I mean, that you're sort of pulling out all the stops and going so far as Eddie Glaude noted, to say, don't believe what you see. Don't believe what you saw, which was an astounding thing to ask the jury to do, particularly a jury on an empty stomach, a jury that's getting hungry, sitting there waiting for him to conclude as they sort of plow through the lunch hour. So to do that, I mean, he seems to be throwing a Hail Mary. Hail Marys sometimes do connect, but that's what it looked and sounded like to me. And I think this afternoon, the prosecution, which gets a rebuttal, can hit some of the points that specific points that Attorney Nelson has highlighted, but also do what he did. Play the videotape, show the jurors again, reinforce what they do in fact see, and tell them to believe their eyes. And I think that's always been the most effective evidence in this case, and I expect the prosecution to present it in a passionate way in their rebuttal this afternoon.
It's disturbing even just to see all this video over and over again played out before us. Thank you to Eddie Glaude, chairman of the Department of African American Studies at Princeton, and thank you to Eugene Robinson. We're going to take a brief break. The judge has granted a lunch break right now in the closing arguments in the trial of Derek Chauvin. The proceedings should resume within the next half hour or so, so please stay close. We'll return to our live coverage at that time. For now, I'm Kate Snow, and we'll see you back soon.